So even though we're withdrawing, we'd still ask that he be given an opportunity to represent himself pro se and argue on the
We'll have
merits.
to have a hearing whether he's capable of doing that. Mr. Perez, we'll have to have a hearing with him.
Okay.
To see if he's competent to represent himself on that.
Okay.
It is this positive sort of motion, so. Okay, well, I'll sign the order for you to withdraw. You sure you don't want to stay on the case until that's over? There's room for you.
That's not my call, Your Honor.
Okay, well, if you got an order prepared,
I should have, I think I e-filed one, but if I didn't, I can.
we'll e-enter it then, okay?
Okay.
Thank you very much. We'll make sure that we call the case back up and tell them that you did appear.
Okay, thank you, Your Honor. May I be excused?
Yeah, absolutely, yeah. Okay, Commonwealth versus, is the Harlan County Detention Center is scheduled at 10, right? Okay. Commonwealth versus Christie Bay. Christie Bay.
Good morning, Your Honor.
Commonwealth versus Christie Bay. Are you Christie Bay?
Yes,
Born in 1974,
no, 1976.
76, we'll note that. Last four digits, social security 2047.
Yes.
We're here for a pretrial conference in 24 CR 0019. What does the Commonwealth have to say?
Well, Mr. Kraus wants one more investigation today. I'm where I'm at, either try the case or settle it.
Your Honor, and the basis for our request is Mr. Stockton has advised me finally this morning that the co-defendant is taking a plea. Apparently it's being done today.
No.
Oh, it's not.
That's
Okay,
not correct.
okay.
He said he would probably take a plea, but he said he did not want to take the blame of any of the contraband. Says it was Miss Davis, so
Well, that's kind of what we're getting at. And see, you all got a statement from him?
no, I just plan on, both of them don't say they're going to try the case. Yeah.
Are we conducting discovery here?
Well, semi, it's, everybody's here. It's hard to get everybody together.
If you're out here on negotiation, then you know these.
Well,
things.
we discussed it on negotiation. Yeah, I think we can sort through it better. I met with Miss Beatty this morning and advised her of Mr. Stockton's offer.
What was the offer?
Well, it's basically a probated felony.
Yeah, but some home incarceration, SSC. So.
Well, what are you negotiating about if that's not acceptable? There, let's just set it for a trial. I mean, she's got a right to a trial.
Set for trial, that's fine, Your Honor.
You agree with that, Mr. Stockton?
Yeah, that's fine. So that's what I intended to do. And I
That's
guess we
fine
need
with
to get the same day Mr. Pinion up here, because I want to set Mr. Murdoch the same day.
Okay.
She.
If we got, it's going to change things, make sure everybody. It's going to be a fun.
You know,
Mhm.
it's, we'll see.
Okay. Mr. Pinion, where is your client here?
Judge, you had inquired about Harlan County, that's where he's at. And Judge, I don't
Will he
care.
be there a while, or is he being held on this case?
Judge, he's a state inmate, he's got charges out of Pulaski.
Okay, well, we can set a date. Yeah, it'll take 1 or 2 days to try. to-
One day, yeah, I think one day.
Yeah, is there lab work involved?
There it is. We just need to check today. I'm not sure they're right.
It's thunderstruck, co-defendants, incarcerated, as state prisoner.
On July the 17th, we have Williams versus Straw.
That's settled, Your Honor.
That date's fine.
Yeah, I'm open, yeah.
Okay.
You're getting an agreed order on the issue between the Bank of Salina and Williams is settled, and you're getting a summary judgment on the rest. So, yeah, we can do this that day.
Does that work for me as well?
That's.
Just kind of about you.
July 17th. You just spoke too soon.
Were you gonna need Mr. Murdoch or anything else?
No, no, Judge.
Hey, Arnold Bell. Humble versus Arnold Bell.
You know who he is, sorry?
I have tried, I've talked to his sister, I just one. Judge, this is the one that he was in drug court and got terminated for medical reasons. And was never put back on active probation. This was a motion to put him back on active probation. And I have tried all the addresses, we've got his address here is also his sister,
So
which is
he's
on my
scarce,
caseload.
is what you're telling me, he's scarce.
I found an address for Tennessee and I give that address to the Commonwealth and they mailed a motion to that address, so,
So this issue a bench warrant for him.
okay.
And what we can do is when they pick him up, I'll set him a very reasonable bond that'll get him back in the system.
Thank you, Judge. That's all I was gonna ask, just.
And as soon as he gets picked up, I can start supervising it, just,
Well, we'll see what his circumstances, if he's other charges when he
Yeah.
get picked up.
That's just medical reasons, like, I guess my first inclination, I'm not sure he's still around, but DPA doesn't know
But
that.
he's not, he's being
Um,
charged.
I asked local law enforcement because they've dealt with him for years. And everybody I've talked to, they've not seen him in a long time, that he's,
But we'll find
Scarce.
out, yeah, scarce. Andrea, Tyler,
That's a Commonwealth motion to destroy evidence in that case, in the Commonwealth's, in the defendant's case.
you're electronically signed.
Yes, thank you.
Commonwealth versus Charles Christie. Sentencing. Commonwealth versus Charles Chrisley, 23 CR 0061. Are you Mr. Chrisley?
Yes, sir.
Born in 1974.
Yes, sir.
Last four digits of social security number 3640.
Yes, sir.
You're on 23 CR 0061, as I said, for sentencing, and you had an opportunity to look at pre-sentence investigation for mental probation.
Yes, sir, I
Is it substantially correct?
Yes, sir.
Is there any reason counsel other than shall be sentenced?
No, Your Honor.
On plea of guilty to burglary in third degree and persistent felony offense, the defendant shall receive the sentence of 10 years upon plea of guilty to criminal mischief. First degree and persistent felony, second shall receive 2 years upon plea of guilty to theft and all taking disposition more than $500, less than $1,000. But shall receive a sentence of 12 years. The sentence, however, shall run currently for a total of 10 years, serve 120 days in jail with the balance probably 5 years supervised. If the defendant has yet to serve 120 days in jail, the remaining shall be served on in-home incarceration. It should pay restitution in the amount of $4,075. With $200 per month within 30 days of the entry of the plea. Have those payments been made? You made the payments?
I wasn't where I was supposed to until I was finally sentenced, sir.
It says right here. For $200 per month, the first payment in 30 days that entry ever approved.
I've got that today if I need to pay that.
And my fault, Judge, I think with Mr. Chrisley, he had pled guilty in Cumberland County, so I think that.
Well, we're not gonna be doing those anymore.
I
It's causing
understand,
all
Judge.
kinds of problems.
I apologize.
What day did he enter the plea? Let me see here, I can find out. The plea document I have is not dated.
Judge, I'm thinking it was late April.
April, end of April. When
So he had to pay two payments.
It was April because we had a trial May the first and we entered the plea before the
Yeah,
trial.
so he should have paid two payments. So I wanted to pay two payments of $200. He had one payment due in May and one in June. If he pled in April, right?
No, Judge, I don't think the June payment wouldn't be due yet, so he would have the May payment.
What was the date of the plea?
I think it was the end of May.
25th April.
So he'll have another one due on the 25th.
Correct, Judge.
Pay one today and the other 200 on the 25th.
Your Honor, may I have a little grace, because I wasn't aware of that. Could I have a little grace and pay both payments by the 25th?
I can do that.
Thank you.
Thank you, Judge.
Thank you, sir.
What are the court costs?
155.
$155, and I'll let you pay that. It means $30 a month, the first payment being 30 days from today.
Thank you.
You need to meet with probation parole officer.
Thank
Of
you.
course, there were other conditions about you staying away. No contact with the victim's real estate, and the job ain't 30 days.
And Judge, he's done that. Mr. Chrisley works at a rehabilitation center currently full-time, so.
Okay, that's fine.
Your Honor, there's a stipulation of my bond that I stay out of Clinton and Cumberland County. Is that lifted? Can I come home every once in a while now?
Mr. Stockton,
I have no problem as long as he stays out of trouble.
All right,
okay,
thank you.
Thank you, Judge.
Luther D. Connor,
What?
Luther D. Connor.
Let me get the phone number.
Your Honor, that's our, this is the F case. What happened was, Mr. Connor was arrested by Fish and Wildlife. His muzzle loader was confiscated along with what the officer thought was methamphetamine. It was sent to the lab. There was no controlled substance. So the Fish and Wildlife still has the muzzle loader. It either needs to be returned to Mr. Connor. He's not here today, so I just asked that they be able to dispose of it according to state law.
I have no objection in, especially as far as methamphetamine goes, but I've not been in contact with Mr. Connor, so.
Well, I can give you 30 days. We're going to order having him pick it up in 30 days, or otherwise we'll be.
Do we know where he is?
Last address we had for him was on Cat and Mouse Road here in Albany.
Cat and Mouse Road.
Incarcerated?
I think he
I-
made-
And you gotta be careful, there's two different Luther companies.
We had.
Three
And three different, I was gonna say there's three different Luther Connors.
The last one, it was the wrong.
Wrong one, yes. So that's not him.
That would be nice.
Yeah, it's the older man.
He just won't, that's it on here.
No, it's a son.
I think this is the young,
Because we had the
Yep,
older gentleman
Okay,
on
well,
Zoom
just got it back.
last.
yep,
Well, let's draft an order and tell him that those charges have been dismissed, but that the Fish and Wildlife still has that weapon and he should claim it in 30 days or it shall be disposed of according to law.
That's right.
yes, Your Honor.
You will come around, Mr. Grand Jury member? You swear or affirm that you will hear and weigh carefully all the evidence presented to you and that you will do your duty as prescribed by law and that you will carry out carefully the investigation which you are requested to do. Position you taken from the constitutional power of the United States of America.
Yes.
Go with the clerk. You met the clerk? Troy Coots. It's an expungement here. Is there any objection?
No objection, Your Honor. And I didn't file a response because that case was dismissed.
Okay, Alicia Coria.
So I don't know if I'm confused or not, but I sent Mr. Poindexter an offer by text. He said he was in the US Virgin Islands and he said he would get back with me this week. Did this case get moved to another county or something? Because she's not here.
We heard it in Cumberland, we had a pre-trial in Cumberland County.
And it was
they set
supposed to
for
be back
pre-trial
here.
today. But it's my understanding Mr. Poindexter still out of the country.
That's what I thought.
And
The response to the text,
Judge, if I may, not on this case, but I spoke with Mr. Poindexter last night, and was asked to cover a case, not this one, but a case on today's docket.
that's where we're at. I don't know, was she not here? No.
What's your charge with?
Assault, third and DUI.
Well, there wasn't any move for a continuance or anything.
I thought she would be here anyway.
Yeah, well, you should bench warrant.
There is one time saying that the next court appearance will be on July the fifth, that's Kern County Judge Center. May 31st.
So that's a negotiation conference. But it says that it's showing that there's a pre-trial already.
Doing over, maybe it's Thursday morning, you're been here in Clinton County.
Yeah, it should be.
So she shouldn't be on the dollar, because that sounds small.
The docket entry says today, the order,
No, it says July 11th.
I mean. The docket entry says July 11th, but it doesn't say the pre-trial, the negotiation day on there. And the negotiation day doesn't say.
This is the negotiation of July 5th and July 11th. This was just the order for the negotiation conference.
Well, I will do an order changing the negotiations, will be July 3rd at 1 p.m. in Burkesville, so I will do an order drafting changing that. And notify him.
But she just shouldn't have been on the docket. There's nothing said.
Yeah.
That's what I.
There was withdraw the bench warrant, shortest bench warrant in history.
Yeah, I just want you to do the order changing the negotiation. Yes, let's Steve and make sure.
Rodney Manis,
I think that.
Commonwealth versus Rodney Manis, 22 CR 007. Are you Rodney Manis?
Yes, sir.
Rodney Manis.
Yes, sir.
Born in 1970.
Correct.
Last four digits, social security number 3024.
Yes, sir.
You're on a probation revocation. You move your left a little bit,
Oh, okay, I'm sorry.
your left.
Oh, okay, oh, wait, okay.
Your Honor, this was my motion to ask that he be revoked because he had new charges in Tennessee, a misdemeanor arrest, theft of property, and also a felony possession of meth. However, he paid $600 in restitution yesterday. So kind of at a loss as to what to do. If he'd stay out of trouble and keep paying his restitution, he'd be good up here. But I don't know what Tennessee's gonna do with him. Both of those charges are in Tennessee.
Yeah, I'm gonna read that.
Say nothing about nothing.
So I'm asking to be revoked today since he paid the $600. He still owes 18,000. So
How much of the pay is supposed to
$200 a month.
be? He's behind and
Well, he paid $2,000 a few months ago. And that kind of caught him up. He was here, I filed a previous motion, he paid the $2,000, that caught him up. Then he hadn't paid anything, and he got these new charges, and then I found out yesterday he paid $600. So he's kind of, I don't know what his problem is, but he needs to pay regularly, not have to be run back and forth to court, he needs to stay out of trouble. That's my position.
you want to set him back for a review sometime?
Yes, in a couple months. I think he's good.
You need to be back here in court on August the 8th for a review, see what you got. Well, what happened to Tennessee things.
Can I say one thing, sir?
No.
You want to leave, you better be quiet, get the door.
Here.
Commonwealth versus Lloyd Owens
Car break, Your Honor.
in Clinton County.
Yes.
Timothy Perigin.
No, we did not.
Timothy Perigin,
Yes,
born 1970, last 4 digits, social security number 7331,
7334.
7334. Note the correction on the docket. We're at 23 CR 0064. It says a pretrial conference, but I understand it might be a suppression motion. Is that right?
What your decision, Your Honor?
Yeah. Well, we probably, I'm not going to suppress the search of it. Well, what do we need to do next?
Well, I would suggest one more negotiation day on July the 3rd. If it's not resolved, I'll ask for a trial date on the
Will
11th.
that be in Cumberland County?
It will be, because I'm gonna do all the negotiations for Clinton and Cumberland, in Cumberland till we, get a justice center, because they just have so much better facilities for the prisoners.
July 3rd at 9 AM or 1? Which one? 1 o'clock.
That's fine. Your Honor, if I would request if I could request the court to get the order entered so Mr. Parrish and I can digest it and
Well,
see.
we'll give you a written order on it. You're entitled to a written order on the suppression.
Yeah, I think it's a few days before the third. Thank you.
Fine. Yeah. Put that on that. Taylor Phillips,
Have you got the paperwork to sign?
Taylor Phillips,
Yeah, that's the one, the paperwork needs to be signed.
Commonwealth versus Taylor Phillips, 21 CR 004. Taylor Phillips,
Yes.
born in 1997,
Yes.
4 digits, social security number 5260.
Yes.
Here for the pretrial conference, was a Commonwealth makes that.
Yeah, Your Honor, this is a case where Ms. Phillips entered a plea several years ago. And when it came to be find out that the paperwork was never turned in or wasn't signed, we just needed to get her to sign the paperwork and file it, if that's all right, so.
Was she sentenced and everything?
It was a verdict. Done well, so I can get the paperwork in her and hopefully dismiss the verdict here. That's-
So you just need the orders, granting pretrial version signed.
I think they did.
Judge, I think my understanding, everything needs to be executed. If we could recall Ms. Phillips. I know she's already signed it, but I wasn't the attorney of record.
What date was it supposed to?
Back in 21, I think,
February 10th, 2022.
22, February 10th.
And I believe she's in journal, so.
You got Bill in there now?
2021 or 2022?
The date I have, Judge, is February 10th, 2022.
I'm gonna sign it that date. So post
That's
it
what the document says. Yep.
by agreement. Because of the mission, okay?
Yes, Your Honor.
She have to sign anything or that all? You got it, you're
I
doing.
don't have,
Okay. I know if you need to sign one, he signed it.
Well, I don't have her signature on it. It would be good to have her signature on the one we have here. So you always take that, let her sign it and, let you sign it and they will, and just hand it in. It's great. I guess I handed my docket is under there. Got mixed in.
Have a big one.
My docket,
they don't, got there either. They don't make a cheap sheet, Judge. You know this.
no, you won't like some of them.
I-
Larissa Poor. Larissa Poor. Commonwealth versus Larissa Poor. Are you Larissa Poor?
Yes,
Were you born in 1982?
yes,
Last 4 digits of social security number 2675.
yes.
You're on probation or vacation. Is this one of your clients too here?
Maybe, Judge, actually, she is a co-defendant in the case and in the alleged violation with, Mr. Michael Burchett. He's incarcerated in Clinton County. at the trial court level, they had both executed a waiver for dual representation for Mr. Sheffield. I'm not certain that that would carry over to cover my dual representation. So that's kind of where I'm at, Judge, as far as procedure. I don't know that I can represent both of them in representation.
They both have the same violations in that they moved to Tennessee without permission and had some problems down there. They do have two different violations, and Ms. Poole was charged with theft in Wayne County, and Mr. Burchett was charged with a different charge somewhere else. I can't remember what it was. They have two different.
It doesn't appear to be any conflict.
I would think we could do both hearings together, because
Sorry, see.
he's in Clinton County.
Okay, when you wait around and that comes up, do you have any objection for this gentleman representing both of you,
No.
You signed it previously for your previous attorney. I think out of abundance of caution, you can get another one signed. So if we can get a waiver of dual representation form undersigned, then you just wait around. When we call him up from the jail and have his hearing, we'll have yours too, okay?
Okay.
Anthony Richardson, please. Anthony Richardson. Cromwell versus Anthony Richardson, 24 CI 0020. Good morning. Are you Anthony Richardson? Were you born in 1998? Yes, sir. Last four digits of your social security, 1777. Okay. You're here today for sentencing. Have you had an opportunity to look at pre-sentence investigation report?
You have, Your Honor.
Substantially correct.
Your Honor, the only,
Wait a second. You got, is it substantially correct? And you're saying there needs to be a change?
it reflects the public offender represented Mr. Richardson, and I've advised.
The change.
Yes.
Okay. Is there anything else that may be?
Everything else.
On the plea of guilty possession of controlled substance, first degree methamphetamine, offense to receive a sentence of probation of 5 years. Senate will be residing in the state of Tennessee. As supervision should be transferred as soon as available. Get credit for time served. Shall have gainful employment or 30 hours community service. Agrees that all evidence above style case shall be disposed of. The agencies in Kentucky holding it. What's the court cost?
$150.
$155. You need some time to pay that. You pay the first payment 30 days from today and $30 every 30 days until 155 is paid. Okay, so you'll need to meet with the probation and parole officer right over there. And give him the information, so maybe you can get the supervision sent down there, okay?
All right.
Johnny Stevens. Johnny Stevens. Commonwealth versus Johnny Stevens, 18 CR 0059. Are you Johnny Stevens?
Yes.
You're on probation revocation. You were born in 1977, is that correct?
Yes.
What are the last four digits of your social security number?
3940.
940. You're on probation revocation. What says the Commonwealth? Y'all move to the left.
If I got a good report, Judge.
Yeah, Mr. Stevens has paid this in full. I'm withdrawing the motion.
Mr. Stevens, if everybody did that, it'd put me out of business. Is there any reason for Mr. Stevens to come back and finish with us?
He's finished with us. He still has to answer to Mr. Payne.
Mr. Payne, you need to talk to him before he leaves.
He's on probation till the end of, I think it's October, so,
That's what I was.
yeah.
I hope you have a wonderful Thanksgiving and you're off probation, okay?
All right.
Just be careful, okay? Yeah. Mr. Michael Thompson, it says he is deceased.
Yes, that motion was taken care of with Ms. Bowers' motion about destroying the evidence.
Yeah. Candace Tweedy.
Parson, no.
That's the warrant, she an NCIC.
Yes, Your Honor.
Angela Wallace. Combo versus Angela Wallace, 24 CI 005. Are you Angela Wallace?
Yes, sir.
Born in 1972.
Yes, sir.
Last 4 years of social security number 7871.
Yes, sir.
We're here for a pretrial conference here. So, Mr. Pennington, what do you think?
Your Honor, this case has been dragging out, and it's my fault, but there's a potential co-defendant being presented to the grand jury today, so if we can pass this case, then maybe we can consolidate them and get them resolved.
Go to July the 11th. You want present for negotiation day in
Your
July?
Honor, I would even suggest August, because if we do get this person indicted, it's gonna take a couple of months.
August the 8th, your next court appearance here, you continue on the same bond, okay? Okay, that finishes the docket. We had Lloyd Owens, who's in Clinton County Jail, but I think everybody else was taken care of. Where was Mr. Goodman? So I didn't mark him to Wayne again. Russell County, we're a little early, but if y'all would turn, we'll handle your folks there. Russell County Detention Center. We call Tony Albertson. You want to get your little unmute the thing. Should be a little red microphone looking thing that you hit. Mr. Pennington knows some sign language. Mr. Pennington, all you have to do is.
Like the old Roman, that's all.
Can you hear us now, Your Honor?
We got you. Okay, we're ready for your crew there. Do you have them there or you need to transport them?
If you give us just a moment, we'll have them up here for you.
We're a little early, so just leave your mic on and we'll wait for you.
All righty, thank you, Your Honor.
Is this your ordinance? This is Charles Grizzly. You said that quickly. Restitution. He had it in April. Okay. What are we doing to the temp? What's he doing with the temperature? Do what? So somebody was cool, like had a conflict. Some people have unusual temper. This temperature range, I won't name any names.
Since I was about 12 years ago, I thought who says this? What's that?
Yes, sir.
What do you think about 1 o'clock?
I got him on the day for this year.
Yes, this is like a rehab question. It's one mistake.
I have. We told Charles, David, Christian, if he could come back to Clinton.
Well, that is, well, I see.
Okay, we're ready. Commonwealth versus Tony Albertson. Are you Tony Albertson?
Yes.
Okay, this is 24 CR 0042. We're here for the purpose of arraignment. Were you born in 1984?
Yes.
Last 4 digits, social security number 9471.
Yes.
You're represented by the Office of Public Advocacy. You have the right to remain silent. The grand jury of Clinton County has returned an indictment charging you with escape, second degree, promoting contraband in the first degree, and possession of controlled substance in the first degree methamphetamine. Counselor, do you acknowledge the identity of your client, receipt of the indictment, waive formal rating and arraignment, and reading the indictment, not guilty, reserving all pretrial motions?
Yes, Your Honor, and just if I may, one correction, I'm actually standing in for Mr. Poindexter, so he will actually be representing Mr. Albertson.
Well, I'll assume you have Mr. calendar, so we'll schedule Mr. Albertson to be in Burkesville at 1 o'clock on July the 11th for negotiation.
The third,
Oh, 3rd, excuse me, I had that court date here. July the 3rd. July the 3rd at 1 p.m. We'll need to have a transfer order done for that, okay?
I'll let Mr. Poindexter know, Judge. Thank you.
Okay. Corey Bard. Corey Bard. Are you Corey Bard?
Yeah.
You're here on 24 CR 0039 and 24 CR 0028. Bard, were you born in 1993?
Yeah.
Last 4 digits, social security number 0642.
Yeah.
Okay, you have a right to remain silent. You're represented by the Office of Public Advocacy. Which one is that? Okay, 28, I understand you've already been arraigned on, so on 39. The grand jury of Clinton County has returned an indictment charging you with escape in the second degree, fleeing or evading the police in the second degree, and being a persistent felony offender. You have a right to remain silent. I'm presenting the indictments to your attorney. Counselor, you acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, and plead not guilty, reserve all pretrial motions.
Yes, Your Honor.
The order entered for Mr. Baird to be in Burkesville at 1 o'clock on July 3rd for negotiations. I'm signing a reciprocal discovery order.
Your Honor, I think there's been a KCPC order entered. I will have to wait on this case.
Okay. We will then set a date for negotiation later, okay?
Thank you, Judge.
Okay. Robert Comer. Robert Comer, Commonwealth versus Robert Comer, 24 CR 0037. Are you Robert Comer?
Yes, sir.
Now, do you say Comer or Coomer? Which one?
Coomer.
What'd you say? Coomer. Coomer, okay. Mr. Coomer, were you born in 1975?
Yes, sir.
Last 4 digits, social security number 2424.
Yes, sir.
Okay, you have a right to remain silent. You're represented by Office of Public Advocacy. The grand jury of Clinton County returned an indictment charging public intoxication, possession of drug paraphernalia, possession of controlled substance, methamphetamine, failure to maintain insurance in the vehicle, plates or license. You understand those charges?
Yes, sir.
Okay. Counselor, you acknowledge the identity of your client, receive the indictment, wait formal reading arraignment, and the plea not guilty, reserving all pretrial motions.
Yes, Your Honor.
Now, is this one that gets, scheduled for a negotiation day?
Yes.
Yes, Judge.
Okay, July 3rd, 1 p.m. transportation order, and y'all will need to check and see what his bond is.
Judge, it's my understanding that, Mr. Coomer has a surety bond that doesn't have any, in-state or relatives that could secure that. Judge, I'll note, he's been incarcerated at this point well over 4 months. Judge, I know this is a possession case. I would just ask for a
Mr.
little more
Cooper,
favorable.
where do you live, sir?
30 Horseshoe Bend Road,
I can't hardly hear you, it's clear.
Horseshoe Bend.
That's here in Albany, Clayton County.
So he's a Clinton County resident?
Yes, sir. I've been here 15 years.
I'm willing to take a risk on him if he wants to.
Mr. Coomer, if I change your bond, you won't disappoint us any, will you?
No, sir. I always come to court and
Okay, well, do you have anybody that can sign any bond for you at all?
my daughter can, but she didn't have it was clerk approved and she didn't have the means to.
What's her name?
Mary Lawson.
Well, I'll approve her for a $5,000 surety bond. And under a curfew, you stay at home, except going to work, church, or the doctor. We seem to have a bad connection there. Is it just Mr. Coomer can't hear it, or is the volume low?
The signal's going in and out.
Yeah, I think it is too. Okay, well, you can sign your bond. I approve the Miss Lawson, was that correct?
Mary Lawson, I think.
Yes.
Okay, I'll approve that, and your next appearance will be here in this court will be on July the 11th, and on July 3rd, you're gonna be at Burkesville for a negotiation, okay? And you need to be in
Yes.
touch with your attorney before then, okay?
Yes, sir. Thank you.
Joshua Evans. Joshua Evans. Are you Joshua Evans?
Yes, sir.
You're on 24 CR 0036. Mr. Evans, were you born in 1988?
Yes, sir.
Last four digits, social security number 0079.
Yes, sir.
You're here for the purpose of arraignment, you have a right to remain silent. The grand jury of Clinton County has returned an indictment charging you with public intoxication, possession of controlled substance in the first degree, methamphetamine, and criminal trespass in the second degree. You understand those charges?
Yes, sir.
Okay. Counselor, do you acknowledge the receipt of the identity of your client, receipt indictment, wait formal reading arraignment, enter a plea of not guilty, reserving all pretrial motions?
Yes, Your Honor.
Sign a reciprocal discovery order. Your client shall next be available at Burkesville at 1 o'clock at the Justice Center for negotiations on July the 3rd, and next court appearance at July the 11th. What kind of bond is Mr. Evans under?
I think it's an identical situation, Judge, if I may, as to Mr. Coomer.
He's $15,000 surety.
You don't have anybody that can make the $15,000 surety, Mr. Evans?
No, sir.
Where do you live?
Albany.
Highway, Clinton County, Kentucky, right? What's
Yes.
He did live in small one county and she got in for Charlie's one for him. I don't know.
you're saying what? Yeah.
He did live with his mother's Wayne County. I know there've been several cases up there where he's been charged with criminal trespass.
On her part?
Being at her house.
And he's got a criminal trespass in this case, so I'm just concerned if he's got a place to go, where he'd be.
Where would you live if I let you out on bond?
At Cartwright.
With whom? Who would you live with?
Dwayne Brown.
Can y'all disconnect this Zoom and see if we can get a better connection? Y'all like connect back with us. I'm having really difficult.
Can you hear me now?
That's somewhat better, yeah. You will be living with Wayne Brown.
Yeah, I got another place at, 37 J Cross Road.
Who's that with?
It's an empty trailer. My dad owned it.
Well, y'all know Mr. Brown. Well, you live with that Brown residence, and if you get the trailer fixed up where you can live there, you need to call pre-trial and tell them that's where you are. I'm gonna let you out. Do you have anybody that could sign a $5,000 surety bond for you? Somebody by name that would sign it?
Maybe, sir, maybe my mother.
Well, I understand that your relationship with your mother might not be great, but I'll approve your mother to sign a $5,000 surety bond. What's her name?
Diane Kennedy.
Diane Kennedy. Okay, well, I'll approve that. And you go to the location, Mr. Brown's location, you'll be under curfew. You can go to work, church, or the doctor. Other than that, you stay off the road. You're supposed to be in Burksville on July 3rd at 1 p.m. for negotiation day. You'll be back here July the 11th at 9 a.m. for your next court date, okay?
Who'd you say?
You want to give your address. This, do you have a pencil and paper? Mr. Pennington, well, Mr. Pennington will leave a message there to jail on where you can get a hold of him at, okay? You're a lawyer.
Mr. Evans, they should have my cell number there at the front.
Okay, thank you.
All right.
Kevin Haddix,
Yes, sir. Yes, sir. Begin that.
Kevin Haddix,
Sir. Yes, sir.
15 CR 0036. Says other hearing. What do you have, Mr. Stockton?
We have a 202A petition, but the problem we have is, the owner didn't have a guardian ad litem.
Now it's Miss Sawyer's
Yeah.
as of, I think,
No,
Couple days.
I wasn't sitting on the house until. That's fine.
I thought I signed an order on him, but
Well, Holly Harrison was, she was great. Moved her, and we just was going to another one, and whatever happened, sorry, just recently got pulled out. And so we need time for her to interview Mr. Haddix and have a hearing.
you would.
I guess time for her to interview Mr. Haddix, and have a hearing.
Okay, well, let's just schedule it then for July the 11th.
yes, Your Honor.
Mr. Haddix, your guardian ad litem will be able to talk to you, and you'll be in court here on July the 11th, see if we can get you back in the right track, okay?
All righty, appreciate
Okay,
you.
thank you. Major,
She gonna stipulate or what is it?
Yes, sir.
Commonwealth versus Rebecca Major, 21 CR 0066. You are Rebecca Major.
Yes.
You were born in 1994.
Yes, sir.
That's 4 digit social security number 135.
Yes.
Okay, what do we have, Mr. Stockton?
She has a possession case, 3 years. We were here on April the 12th because she had tested positive for meth and heroin. In lieu of revocation, you ordered her long-term treatment. She was discharged from Protea because of threats of violence. Then she was sent to Sky Hope. She was discharged from Sky Hope. She was disrespectful to staff, argumentative. And on the way out, she said she should have busted the girl's head while she was there. So I'm asking that she be revoked.
You want to stipulate?
Judge, Miss Major's actually asking for help. I mean, I think it's our apparent that she's
Ask what?
for help. Judge,
help,
for a
okay.
dual diagnosis
Understand
facility, help for a dual diagnosis facility to assess not only substance, but also some underlying mental health problems, which is exactly what Mr. Stockton was alluding to with his proffer to the court.
I would disagree with what I was alluding to. I was alluding to that she needs to serve out the rest of her sentence because we
That's
exhausted.
not an illusion, that's.
I thought I was plain spoken myself.
Well, sometimes we all hear what we want to hear.
Exactly. And
Are
again,
you
Judge, I'm just,
stipulating to her being discharged, these two?
I will stipulate to those facts, Your Honor, yes.
Well, I'm gonna go ahead and revoke her, and I think the best thing for her to do is get this behind her. She doesn't have that much time to serve. she can get some help there. You know, that gets her probably out into a facility that's more comfortable than she is now. They'll probably transport her out of there to some other facility. Thank you very much. Good luck to you, Ms. Major.
Yes, Your Honor.
Ashley McCusker.
Can I go back to the suit?
23 CR 0049. Are you Ashley McCusker?
Yes,
Were you born in 1907?
yes,
Last four digits of your social security number 4575.
yes.
You're on a probation revocation. What does the Commonwealth have to say? What do you have?
Ms. McCusker's on probation. This is 3 year sentence on possession too. That fella.
It's a misdemeanor.
Misdemeanor probation, I'm sorry. But she was on 5/28/24. She was on site positive for meth, THC and Suboxone. And she got misdemeanor arrest DUI on 6/5/24. It's the allegation.
She have a conviction on misdemeanor.
No, it's recent. She was only arrested.
No, I mean, what's she in on? Is it is it a felony charge?
12-month misdemeanor. I haven't said what the charge was.
You want to take some tests? She want to stipulate.
And Mr. Pennington wanted a little time on this to see if she could go long-term treatment. And
Well, the only problem that I've got on this is the operation of motor vehicle while they're on probation. Guns and operating vehicle are the two things that bother me the most. So we can have a hearing on it, or she can stipulate.
Well, Judge, I understand, and I guess with regards to the DUI,
I will tell the court, I advise the court, we were also presenting cases on the DUI and wanting endangerment because our children, that's going to the grand jury
Today,
today. Yes, so we
let's just put this off then till July the 11th.
yes, Your Honor.
We might as well have a negotiation day on July 3rd too.
I think that
They're
makes
gonna
sense.
transport you to Burkesville on July 3rd for negotiation and July 11th. Yes, they said the grand jury is gonna take some action today or is expected to take some action. So we'll try to wrap all this thing up together for you, okay?
Okay.
Speak to you, Ashley.
Mm-hmm.
Caldwell versus Phelps. Jerry Phelps.
Yeah, I just go on that.
No. Your Honor, due to the nature of his charges, we have to pull him out separate from everyone else. Can we get him last?
I can't understand
Is
what,
it due to the nature of his charges?
okay, we'll bring him last then. John Smith. Commonwealth versus John Smith. Are you John Smith?
Yes, Your Honor.
Okay, and it looks like Mr. Smith was born in 1987. Last four digits of social security number 5238. You were held $2 for attending as a competency hearing. You moved to your left. Stockton, what do you have?
I have, this is our motion for counsel, Dr. James Anderson evaluated Mr. Smith and filed a report that he was competent and more prepared for a hearing.
Your Honor, I am not prepared to proceed with the hearing today. Mr. Smith is in Russell County. I thought he was in Clinton. And I have not been over there to meet with him. There's a possibility of stipulation based on the report, but and there's also a possibility I may not continue with Mr. Smith's representation. His family brother hired me, who's my neighbor, and
What's he charged with? Come back over here to the mic.
DUI first, aggravating circumstances and wanton endangerment. He ran into a victim when he was operating a motor vehicle or
Okay, well,
intoxicated.
this competency hearing has been scheduled for today.
I understand, Your Honor. And I have not met with Mr. Smith. I have not got over there. I'm sorry.
What's Commonwealth's position?
I'll proceed or not proceed. I'll leave it up to the court. Dr. Anderson's here with them, so hopefully he's not been too crazy.
Your Honor, I feel like there's a likelihood of stipulation, but I've got to sit down with Mr. Smith.
Well, let's just hear the evidence and I'll take it under advisement.
Well, if you leave the record open, that's fine.
Yeah.
That's fine.
You can call your first.
Call Dr. James Anderson, Your Honor.
Dr. Anderson, you raise your right hand. You swear the testimony that you're about to give is the truth, the whole truth, and nothing but the truth.
Yes, I do.
Okay, lower your hand, identify yourself and what your credential is.
My name is Dr. James Anderson. I'm a licensed psychologist, have a PhD in psychology. I'm employed with the Kentucky Correctional Psychiatric Center as a contract evaluator to evaluate defendants for competency and criminal responsibility to assist the courts.
Dr. Anderson, could you briefly describe your education and training as regards your profession?
Yes, I have a PhD in psychology. I've been licensed to practice psychology in Kentucky since 2008. I've been employed with the Kentucky Correctional Psychiatric Center since 2015. I briefly took a position as a chief psychologist at Kentucky State Reformatory in 2022, and I returned to KCPC in 2023 last year. At this point, apologize, I also have a private practice where I do these evaluations for Indiana. At this point, I've completed 731 evaluations of competency to stand trial, 367 criminal responsibility evaluations, and I've testified on 225 occasions.
Now, did you receive a court order to evaluate Mr. John L. Smith as regards his competency to stand trial?
Yes.
And also about whether he had any type of intellectual disability?
Yes.
Okay. Could you tell the court what methods you used to evaluate him and what your conclusions were?
I interviewed him. I also gave him a brief intelligence measure, and he scored in the low average range for the IQ measure. He graduated high school, enlisted in the service, so obviously passed an entrance exam. There's no evidence that he would have an intellectual disability. Interviewed him about the psycholegal matters using the evaluation of competency to stand trial, which is a semi-structured interview designed for that purpose. He provided responses I thought that were very good. They were insightful. There was no evidence of psychosis. And so ultimately, it's my opinion that he would be competent to stand trial.
Did you have any psychiatric diagnosis of Mr. Smith?
Yes, it was my impression that he likely has an unspecified trauma and stressor related disorder. What that basically means is a lot of symptoms that we commonly think of as PTSD. He may not meet the strict criteria from the DSM for PTSD. But we see this with a lot of veterans where there is still some type of emotional abreaction, some anger, sleep disturbance, and stress that is PTSD-like, even if it doesn't meet that strict criteria. He does have combat experience in the service. I also believe that he meets criteria for methamphetamine use disorder and cannabis use disorder.
Okay. And did you form an opinion as regards his competency to stand trial?
Yes, it was my opinion that he would be competent to stand trial.
Okay, I have no further questions, Your Honor.
Doctor, am I correct regarding Mr. Smith's condition? This is an episodic condition that occurs periodically when triggered. Is that correct?
Are you speaking about the trauma disorder?
The PTSD or PTSD light, I think the first.
Sure. Well, it's tough to say. This is something that he would likely be hypervigilant, meaning he's more likely to react and emotionally to certain situations. So in that sense, it may be episodic. He has a tendency to be angry more often. There's some adjustment issues, some mood regulation issues, but it is more emotional. It's not a psychotic disturbance.
Now, doctor, did you examine Mr. Smith remotely or in person?
It was remotely.
Okay. And how long did your exam take?
Let me see here. I met with him for about 1.5 hours.
Okay. So basically, your report simply reflects his condition at the time you conducted the examination. Is that correct?
When we're talking about the competency, yes.
Okay, right. And did you have an opportunity to review other medical or psychological records or psychiatric records regarding Mr. Smith?
I did not. The only records that I had the opportunity to review were the uniform citation, the Kentucky Uniform Police Traffic Collision Report, the indictment, the lab report, the plea offer. And then there is a questionnaire that KCPC typically does between the nurse at KCPC and the medical staff at the jail.
That's all I have at this time, Your Honor. Thank you.
May the witness be excused. Doctor, thank you for appearing here today remotely. You may be excused.
Thank you, Your Honor.
Your Honor, if
Quit shuffling in front of the microphone.
forgive me.
Yeah.
Your Honor, if the court would allow me the opportunity to meet with Mr. Smith, and it's interesting that, as occasionally happens, no records were furnished to the examiner, but if the court would pass it until the next motion day, and I'll be advising and meeting with Mr. Stockton prior to the next negotiation day regarding what.
Let's schedule him on the negotiation day, July 3rd at 1 p.m. in Burkesville, next court date, July 11th. What's his actual charge?
It's one endangerment, DUI first, aggravated circumstance.
Yeah, is there anything?
Oh, that's
It was, but did he have someone in the vehicle with him?
No, he hit another vehicle,
Okay,
damaged car.
okay, well, we'll, Mr. Cross will be over, Mr. Smith to talk to you.
Your Honor, the court have a transportation order here where he can be in Burkesville in person on the
You
third.
need to go ahead.
I'll do an order.
Okay.
Thank you.
We'll have you in Burkesville. Laura Stinson is next. Mr. Laura Stinson. I'm sorry. Ms. Stinson has provided a financial statement affidavit. I find that she is indigent, and I will sign the order appointing the office of public advocacy. Ms. Stinson, you have an attorney now, Mr. Pimpton. Mr. Pimpton, and he's here. Can you see him? Can you see Mr. Pimpton? I don't see her on the
I don't
screen.
see Miss Stinson, but I don't see Russell at all.
Wayne County,
Russell's.
Wayne County's there, but I don't see
Russell's
Russell.
not there.
Russell, will you get back on, I guess?
Judge, I believe if you wanted to, Harlan's on for Mr. Murdoch. I know we had kind of dealt with
This is
this.
next. Harlan County, you want to come on? Oh, Mr. Murdoch, I guess the attorney for the co-defendant was here earlier, and we've scheduled a negotiation date for you for for July the 3rd in Burkesville. We need a transportation order for him on that date. Your lawyer will be in contact with you soon, but we will have you transported to Burkesville on July the 3rd for a negotiation date in your next court.
Yeah, Judge, it's just a trial, but I honestly expect Mr. Murdoch to enter a plea.
What is the date then?
July 17th.
17th.
I got the wrong. We set the trial date for July 17th. And for you and the co-defendant?
Correct.
Yeah, and then your attorney will be able to see you right soon. Do you have an offer on the table, Mr.
We do, Judge. Andrew, I'll be able to talk to you. He's in Harlan, Judge, so he's in my neck of the woods.
Well, it's beautiful in Harlan this time of year, so. Okay, your attorney will be able to talk to you, see what the offer is, and he's got some other state charges. and-
Correct, Judge. He's actually in Harlan doing the SAT program now.
Okay, well, he'll be able to see you. Okay, thank you, Harlan. Thank y'all for cooperating. You can be excused and released, Harlan. You know, let's go back and see if we can get Russell County back on the line. Are they back on, there they are.
There's Ms. Stinson.
Laura Stinson, are you Laura Stinson? Miss Stinson, can you hear me? The microphone is muted. Somebody needs to come back over to the computer and push the little red microphone. There you go. Can you hear me now, Miss Stinson?
Yes,
Okay, are you Laura Stinson?
yes, sir.
Born in 1987.
Yes, sir.
Last four digits, social security number 4707.
No, 4704.
4704. Boy, we had a lot of bad social security numbers on here today. We'll change that. This is 23 CR 0016. You're here for the purpose of arraignment. You represent the Office of Public Advocacy. You have a right to remain silent. The grand jury of Clinton County's returned an indictment charging you with theft and deception. Do you understand what that charge is? And I'm not asking you whether you did it or not, but you understand what the charge is.
I think so, yes.
Counselor, do you acknowledge the identity of your client, received indictment, waive formal reading and arraignment, enter plea not guilty, reserving all pretrial motions?
Yes, Your Honor.
I'm signing a reciprocal discovery order here. Ms. Stinson, also known as Laura Ferris, for the Commonwealth to provide you with all the information they have to help you prepare for defense. We'll schedule a negotiation date for July the 3rd at 1 o'clock in Burkesville. There'll need to be a transportation order issued for that date, and the next court date is here in Clinton County on July the 11th. Now, what is the bond in her case?
She was in NCIC over a year, Your Honor.
Okay, well, if you want a bond reduction, you'll have to set a hearing. Your attorney will be over to talk to you. Now, Russell County,
One more.
Jesse Pittman, Pitt,
He's a one.
Phelps.
We have Phelps.
Phelps. Oh, yeah, that's right. How do you say that first name? Jerry
Yes, sir, Jerry.
Phelps? J Ray Phelps,
Yes, sir.
24 CR 0027. Mr. Phelps, were you born in 1993?
Yes, sir.
The last four digits, social security number 4673. Okay, okay, 4673. You're here today for pretrial conference. What does the Commonwealth have to say, Mr. Stockton?
We're attempting to get medical records out of Tennessee in this case. And that's what our discussion is about, and we should have those shortly. And so we can set one more negotiation.
You wanted to say a negotiation day for July 3rd?
Yes.
Yes, Your Honor.
Negotiation day for July 3rd. The next court appearance is July 11th.
And Judge, just for the record, I've discussed this with my client. There is a potential conflict of interest in this case. I'm exploring that with the Department of Public Advocacy, but if there's any action, I'll have them expedite things, given where we're at on this case. But I just wanted to.
Okay, thank you.
Yes, Your Honor, thank you.
Okay, Russell County, your attorney will be over there, Mr. Ray, to talk to you concerning this negotiation. So is there anyone else there in Russell County that we need?
No, Your Honor, that's it.
Okay, thank you. Y'all are excused.
All right, thank you, Your Honor.
Let's go to Wayne County. Wayne County. We got Thomas Tucker in Wayne County. Are you Thomas Tucker?
Sir, Your Honor.
Okay, this is 24 CR 0034, Commonwealth, Kentucky versus Thomas Tucker. Mr. Tucker, were you born in 1986?
Yes, sir, Your Honor.
This four digits, social security number 8482. You're here
Yes,
today.
sir, Your Honor.
Here today for the purpose of arraignment. You have a right to remain silent. Your attorney is present and can see you. You can see him on camera too. The grand
Yes,
jury,
sir.
The grand jury of Clinton County has returned an indictment charging you with 8 counts of wanton endangerment in the first degree. You understand what those charges mean?
Yes, sir, Your Honor.
Okay, and then also unlawful imprisonment in the first degree,
Yes, sir.
terroristic threatening in the third degree, violation of Kentucky DVO, possession of a handgun by a convicted felon, and being a persistent felony offender, 9 counts. You understand what those charges are?
Yes, sir, Your Honor.
Counselor, do you acknowledge the identity of the client received indictment, way formal reason around the plea not guilty, reserving all pretrial motions?
Yes, Your Honor.
Sign a reciprocal discovery order that requires the Commonwealth to provide, so you all the information to help you prepare for the defense. You want him over there for a negotiation day?
Yeah, that'd be fine.
Negotiation day in Burkesville on July the 3rd. And then the next court date is here in Clinton County on July the 11th. And your attorney will be over to explain and help you prepare for those things, okay?
Yes, sir, Your Honor.
Now, let's go back. We have Jesse Pittman. Jesse Pittman there. Is Jesse Pittman in Wayne County?
Just logged on.
Yeah, it's logged off, and he is, they just logged off.
They may not know that I had him because I didn't have him on the list because he was supposed to be tricky.
Is there 1142 in the file? Because I don't recall seeing one. RCR 1142 motion, because he said he wanted to argue that, but when he said that,
It's the same.
because I usually respond to those. I get it.
It was the
There was a.
handwritten, yeah, and I don't even know that it was captioned, but it was the pre-motion before DPA.
Well, he needs an attorney. We're gonna have to have a hearing, and I need to get prepared for whatever the motion we're gonna have. Stop.
Yeah, it's a 6002.
6002.
It's not an 1142. It's a motion to vacate or correct sentence, so that would be a 6002.
But there is a motion in there from the attorney to withdraw as the attorney.
That's everything.
Yeah, that's all I know, second.
Do we need to come back on?
That isn't, that's
No.
not a hearing.
What we'll do is send him a notice, copy of the order that his attorney has withdrawn. And give him 30 days to get another attorney and place him on the docket next month here.
That'd be fine. Yeah.
Okay? Go ahead and interrogate, he needs to appear here. You know,
Where's
with his
Mr.
attorney.
Pittman? She's on.
Pardon?
Mr. Pittman.
Oh, Mr. Pittman. Mr. Pittman, can you hear me now? Somebody needs to unlock the microphone for Mr. Pittman.
I think I've got it now, sir.
Yeah, okay, Mr. Pittman, your attorney appeared earlier and withdrew. You have a motion to alter, amend, and vacate that's filed, is that correct?
Yes, sir.
Yeah, you want to argue that now? I hear what you have to say about that.
Yes, sir, Your Honor.
You
said-
you don't want an attorney, is that right?
No, I'm fine. I can move forward myself.
Go ahead.
Okay, as you knew, I got this deferment over the dismissed cases, and I'm currently doing the parole. You know, I got my parole revoked, so I'm doing this deferment. And you said the only thing I lacked was grounds, and my grounds for my motion is ineffective assistance of counsel from Mr. Shuffett, because he never even offered to amend the charges, because I mean, it was cut and dry. It was unauthorized use of a motor vehicle. It should have been a Class A misdemeanor, but I ended up with theft, unlawful taking, and a PFO second. So all I'm trying to ask is that my sentence be reduced by 1 to 2 years, and instead of vacating it, all I ask is for a sentence reduction, and that would put me pretty close to doing a class and be able to be done with my sentence. I've already completed 2 programs and been baptized. And also, I just got enough, I finished the deferment that they gave me, the 12 months. And just Monday, they gave me another 12-month deferment on this case. So, I mean, if I can't get any help from the court, I'll be stuck doing another year apparently. And all I ask is just if, y'all can just,
We
if
have
you can
some,
reduce.
we have somebody here from the Department of Correction, will pull your record up. Give us just a second, okay?
Okay, sir.
Followed as an alter to vacate or correct sentence, but in the body, he claims ineffective assistance. I don't know which one it is, and that needs to be clarified because there's a different standard.
The motion it filed, it has a motion to alter, amend, or vacate, and then you have inside that motion, although it's not included in the title, we've been informed that y'all are picking up on the microphone. Also, it has an ineffective assistance of counsel. There are separate findings that are necessary on ineffective assistance of counsel and alter, amend, vacate. You really need some legal advice on this thing. But the Commonwealth's looking at your record right now, so let's see what the story is.
Your Honor, I'm willing to do something or if he could come out and be on probation because he's got 5 years and 10 months in already in 12 days on his sentence.
Come on up where I can hear you a little bit.
He has served 5 years and 10 months on this sentence already.
Yeah.
And he's only got a year left, even if he meets the parole board in August, he'd serve out in probably 6 more months. So if he'd be willing to where we could alter to amend the sentence to where he would come out on probation, I'd be willing to release him because he had a job at Tyson. I don't know if you can get that.
Yes,
back.
sir. Yes, sir. I'll be able to.
You have any suggestion on what order we in?
I'm trying to think. We could do a 60-02 motion. We could do a 60-02 order. Alter or amending the sentence to a lesser degree, but I'm trying to figure out how we'd keep him on probation. I'm having to think here, Mr. Pitton.
Okay, that's fine. I appreciate you working with me, Jesse.
Yeah, so I have to figure out, we could amend it where you just be out and there wouldn't be no strings attached. But.
And I would still continue to owe a little bit of restitution. If you would do that, I'll pay my restitution off completely or leave it.
Wait a second.
That's the thing. I want to amend it to where you could get out and pay is what I'm wanting to do, where I'd still.
Yeah,
have a
okay.
hold. So.
Well, what could we probate the rest of the sentence?
I've never seen this happen, Judge.
That's the Moreland process.
Yeah.
We can't probate.
Yeah, we've lost control over it. Well,
How much restitution is that?
we could I tell you what we could do is we could vacate it and let him enter another plea.
I think that'd be the way to do it. Would you be willing to do that?
Yes, sir.
Okay, well, I'll enter an order of vacating and have him to appear here in court on July the 11th.
If we do a transportation order to have you down July the 3rd, so we can do the paperwork, and then we can enter at the 11th and try to get you out.
Okay, they'll possibly, Jesse, they may try to kick me out on house arrest before then. As DOC, I'll be eligible for HIP in 2 or 3 weeks.
Well,
Is there any way that we could?
Wait a second.
If he gets out on house arrest, then we wouldn't have to do it. But would you be able to
But
work?
that's, yep, I wouldn't be able to, it'd be hard to
Wait
work.
just a second, wait just a second.
Well, let's set him up for July the 3rd. That's our regular negotiation date. And we'll know something. We'll do one or the other. Okay, and we'll have you transported.
All right.
We'll have you
Yeah,
transported,
no,
we'll have you transported to Burkesville in July, the 3rd at 1 o'clock, and we'll go ahead and you need to submit the transfer since he's
We'll submit the
unrepresented.
transport order. We'll
And
do
then,
some one of the two.
and then negotiation will happen over there and we'll enter an order to try to accomplish what you want to.
okay, sir, that'd be great. Thank you, guys.
Thank you, yeah. Okay, now, is there anything else in Wayne County? If not, Wayne County can be excused. And we'll go to Clinton County.
I'll try to end this. There's nobody else here, Your Honor, if you want me to,
Let's
I'll
turn
try
it
to end it. Okay, see you guys.
I'll look forward to that. You got it. I've heard of the inmates running the prison and we've actually seen it happen.
We've got proof.
Okay, Clinton County. Michael Burchett.
Yeah, Larissa Power and Michael Burchett together.
Well, I'll give you that.
Judge, I'm finishing Mr. Burchett's waiver of dual representation. I've not been over to the jail since the court had made that decision, so if it's even needed.
Mr. Burchett, do you have any problem? What's the co-defendant's name?
Larissa Power.
You have any problem with Miss Larissa Poor sharing a lawyer with you, having the same lawyer? Mr. Burchett, are you there? Do you have any problem with you and Miss Poor having the same lawyer? I already signed a waiver before allowing the same lawyer to represent both of you. Do you have any objection to that now? Are we frozen there? It looks like we might be frozen. Can you hear me, Mr. Burchett?
Yes, I can.
Do you have any objection to being represented by the same lawyer that represents Mrs. Poor?
No, I don't.
Okay. We've got breaking up going on there too. Okay, he said he didn't have any problem. You want to proceed?
I do, I call Mr. Payne, please.
Okay. Man, you want to go over there and sit down to the defense table? Can you hear us now, Mr. Burchett?
Yes, I can.
Okay, we're gonna call the first witness. You raise your right hand, sir. Swear the testimony you're about to give is the truth, whole truth, nothing but.
Yes, sir.
Sit down.
Your Honor.
Okay, go ahead, identify yourself.
Officer Carson Payne, Kentucky Department of Corrections, Division of Probation and Parole. I supervise probation and parolees out of Clinton County Circuit Court.
Okay, have you been attempting to supervise Michael Burchett and Larissa Power?
I have, sir.
And how long have they been on your caseload?
They was brought while I was gone, they was placed on inactive. And they were brought back to active in let's see here, let me get the exact date. In April
April of when?
of 24.
Okay, and now, when they were placed back on active supervision, what happened?
So when they was placed back on active supervision, they advised me they had been living in Tennessee. I told them that they could not be in Tennessee, that they had to be in Kentucky, that while they was on inactive, if they was to move to Tennessee, they had to let us know. They did not let our office know that they had moved. And I told them they had to reside in Kentucky. Due to them already being in Tennessee, a ICOTS transfer would be hard to get approved. So I told them they had to move back to Kentucky.
Okay.
Well, I got complaint after complaint that they were still in Tennessee, that they were down there in riffraff, and that they needed to be, and I called them in a second time and I told them they could not be in Tennessee without permission. And at that time, I tried to submit a transfer to Tennessee to transfer their probation down there. They brought paperwork in that they had rented a place and they brought a copy of the lease in. They advised me that they were living by themselves down there, just them two.
What did you find out?
Well, I found out that they was living with other people, that I've got a list of who all was there.
That's fine.
But yeah, they was living with other people in Tennessee. And I told them, point blank, both in my office, that they could not be in Tennessee until this transfer is accepted. If they was in Tennessee, it was gonna be rejected, and it's a one-shot time. One time, one and done.
Did you get any complaints from Tennessee about them being down?
Well, what happened was I submitted it, then when Tennessee denied the transfer, they advised me that when they went to do the home visit, that Miss Poor and Mr. Burchett were there, and that they were told, let's see,
Your Honor, this time I would.
I have got,
Hold on, this time I would check, Judge, at this point, this officer is attempting to testify to alleged investigation by Tennessee probation and parole. So not only hearsay, we've got problems with this being a different state authority that's doing this
I'll
investigation.
take judicial notice that Tennessee is a different state.
Yes, Your Honor.
Okay, go ahead.
Okay, what did you find
all
out? from
right,
Tennessee?
I'm gonna read the exact statement I received from them. Mr. Burchett and Miss Poor were at home of Lawrence Pool located on 7925 Old Baxter Road, Baxter, Tennessee, when officers Bruce Paplin and Adam Stubbs conducted a home visit. Both Kentucky offenders stated they were instructed by their Kentucky officer to tell any Tennessee investigating officers if they are discovered that they were merely visiting. They was never told that. I told them in my office point blank, if they were in Tennessee at the time of the investigation, it would be rejected.
Was there any allegations that they were possibly taking advantage of an elderly man living at that residence?
I received many complaints about that, and I also, the state of Tennessee felt that way when they rejected the
Your Honor,
transfer.
it's to speculation now, officers talking about.
Yeah, be careful about this speculation. You have to use our common sense.
Okay.
How many complaints did you receive that they were possibly taking advantage of it?
I received numerous phone calls.
Okay, and do you know who they were from?
I do not know who they were anonymous.
Okay, okay. Did they present to you a lease agreement?
They did.
From Mr. Poole?
They did. But they advised me they were the only two living in the home.
Okay.
But the lease agreement's from Mr. Poole. And I also have, the same day that the lease agreement was sent, Mr. Poole received a letter to vacate premises that he was being kicked out.
You have a copy of those leases?
I have a copy of both of them.
Okay, I have those for you. Your Honor, I'm gonna ask that this, notice from Chafin Fitzpatrick and Pinson telling Mr. Poole and all the tenants to vacate the premises of the estate of Sherry Fox be entered as Commonwealth's Exhibit 1.
No objection. Not objection.
And I also asked that the property lease agreement between Michael Burchett and Mr. Poole, dated May 15th, 2024, be entered as next.
Do you want the one for Miss Poor also?
That would be Exhibit 3 from Larissa Poole and Mr. Poole, dated May 15th.
Without objection, so ordered. We got three that here. All right.
Now, couple other questions. Has Mr. Poor, I'm sorry, Miss Poor or Mr. Burchett received criminal charges in the last few months?
Yes, sir. Mr. Burchett. Let's see, on October 25th, 2024, the client was served with criminal complaint summons by Deputy Pendergrass of the Clinton County Sheriff's Office in the charges of terroristic threatening. The summons, the affiliate, Robert Carroll, states that on 4/14/24 at 1400 hours in Russell County, the above named defendant unlawfully committed the offense of terroristic threatening in violation of KRS 508.080 by coming into affiliate's property and threatening to stab and shoot the affiliate.
Did Mr. Burchett report that within 48 hours as he was required to do?
When he was, as soon as they were arrested, they both contacted me because they was arrested at the same time.
Okay, was Miss Poor, did she receive any charges?
She did. On April the 5th, Deputy Pendergrass served her with a warrant of arrest from Wayne County for theft by unlawful taking. The affiliate Allison Perkins states that on 4/11/24 in Wayne County, Kentucky, Larissa Poor committed the act of theft by unlawful taking, all others, when the defendant stole the wallet belonging to Alice Perkins in Walmart, which was caught on surveillance video. When the wallet was later found in the women's bathroom, $80 in cash was missing.
Okay. Now, those cases are still pending, is that correct?
That is, his was pending when I looked at it last week.
Yeah,
Hers, she pled guilty to hers.
okay. Now,
And she had to pay the restitution and she was granted 60-day sentence, probated for 2 years, pay all court costs and fines were paid in full.
since they've been placed back on active supervision, have you been able to verify employment for either?
I have
person?
not. They, at one time, they both advised to me that they would get an employment at McDonald's in Tennessee. And I advised them they could not start working in Tennessee until their transfer was accepted.
Yeah.
They was trying every way in the world to get to Tennessee.
Okay. Now, why is Mr. Burchett in jail and Miss Power is not?
Mr. Burchett was my direct supervisor. He contacted my direct supervisor and advised not being able to go to Tennessee, that he was having suicidal thoughts. And my direct supervisor lodged him for his safety.
And one other last question. Do you know why Miss Power and Mr. Burchett were placed back on active supervision?
Because of their new arrest. They was out going around.
Okay, thank you. No other questions?
Anyone, you have any questions?
I would be lying if I said a few. Officer, you were talking about Michael being lodged there in Clinton County for safety,
Yes,
so it's apparent there's some emotional problems going on with him right now.
I assume.
I don't want him speculating now. He's not a doctor.
Yes.
Well, you wouldn't have to assume that that was what you got directly from your direct supervisor.
My supervisor felt that for his safety, he would be safer in jail pending revocation.
And in your observations with Michael, is that confirmed? Has he noted any problems in your observations?
All the contact I had with Michael, all he cared about, they cared about was getting to Tennessee.
And Mr. Stockton asked you about working, if they had gained employment.
Yes.
You said no.
They advised,
No, you said no.
I said no.
Okay. Then you went on to say that you instructed them not to seek employment in Tennessee, correct?
I told them they could not start working in Tennessee until the transfer was accepted. If they were in the state of Tennessee and Tennessee probation and parole found out, they were going to reject their probation.
And you also, if they can't work in Tennessee, told them they can't live in Tennessee.
Yes. I told them they could not be in the state of Tennessee without permission. I received a call one time from Larissa to go see her mother, and I allowed that, but that was all.
Thank you for that, officer. So Larissa's mother lives in Tennessee.
She's in the nursing home, is my understanding.
That, to your knowledge, is that the only family that they've got in Tennessee?
To my knowledge, yes. But when probation and parole went out to the house, they had more family living at the home with Mr. Lawrence Poole. John Luttrell was there. And so was, I don't know who Jessica White is, but John Luttrell there. And if I'm not wrong, he is a brother-in-law to either Michael or Larissa. He's family.
The more kinfolk in Tennessee. By that?
According to this, at that
document you
residence,
got.
yes.
Okay.
That they advised me that nobody should be at.
And a lot of these anonymous calls that you were getting, you said, wrote this down, that they were anonymous,
Yes,
meaning you don't know who was
I
calling.
don't know.
You don't know if they was in Tennessee or not.
I was getting a lot of phone calls, and they admitted to me they was in Tennessee, and Tennessee probation and parole proved to me they were in Tennessee.
Now, you talked about, I guess, something about taking advantage of a man or something like
Yes.
that. I would be correct to say that there was an executed power of attorney from
There
this
was.
man.
There was, and it was,
So.
it was signed after I told them not to be in Tennessee. They got this signed the date on this is I told them in April they could not be in Tennessee, and this was signed after that.
Well, not when it was signed, I'm just talking, it was signed.
It was signed.
And in that power of attorney, this gentleman is talking about Larissa and Michael helping take care of him, right?
Yes, but they had been.
Helping take care of him,
Yes.
correct?
I just asked that he be allowed to finish his answer.
Well, it's, if he doesn't get the answer, it has no effect, so let him keep interrupting. I'm not getting anything out of it.
I understand, Joe. So again, taking to doctor's appointments, that's what that power of attorney talks about, yes or no?
Yes.
It also talks about taking care of him as a caretaker, both of them, yes or no?
Yes.
There's not been any charges brought up regarding taking advantage of somebody in the state of Tennessee at this time, yes or no?
No, not to my knowledge.
And again, this active supervision, if we sit here and talk, Michael and Larissa have been under active supervision less than 60 days.
They were placed on active supervision in September of 2022. Then they was granted inactive by probation and parole. I'll have to look at the exact date. I'm thinking it was sometime in 23. I'll have to look at the date on that.
And when someone goes from active to inactive, they're being good, right?
Yes, they haven't been caught.
They're being good,
Yes.
correct? And to answer my question, you kind of danced around it a little bit. What was the exact date in 2024 that these folks were placed back on active supervision?
Can I grab my computer, please?
Yeah, absolutely.
I may have it here. On April the 29th.
As we sit here, today's
Yes.
June 13th,
Yes.
so it's been less than 60 days that they've been on active supervision.
This time since they were returned to active supervision.
No further questions, Your Honor.
Don't redirect.
Stand there.
Have no other witness.
You have any witnesses? You
No,
don't-
Judge.
You wanna make your argument?
I did, Judge. I think what was telling, Your Honor, was in the last question and answers, and that was that these folks have been on active supervision for about 45 days. They were living in Tennessee, and I'm not gonna try to excuse the fact that, yep, they should tell probation and parole that they were in Tennessee. But probation and parole granted them inactive supervision because, as officer said, they were being good. They've not had the opportunity to take the precautions that's now being asked of them, which is get up, move from where you're at, where your mother's in the nursing home, where your family's at, come to Kentucky. No, don't work in the state that you're living in. You can't work here. You've got to come to Kentucky.
You know, I thought that they were just asked to stay out of Tennessee until they could get supervision approved down there.
And
It
that-
seemed to me to be to their benefit, because if they were down there without supervision, they'd be in violation of the Kentucky order and probably wouldn't be picked up for supervision in Tennessee. That's the issue. I mean.
That's part of the issue,
maybe-
Judge.
Well, we gotta solve issues a little part at a time. We want some resolution of this thing. I think we ought to find out what it would take
Mr. Payne said they wouldn't accept them as long as they were in Tennessee.
Well, yeah, so we would need to find out what it would take to get them accepted down there and see if they will cooperate.
With it being rejected, Tennessee is more than likely not gonna accept it. If they, my experience with ICOTS is a one and done. If they reject it one
Well-
time,
Well, wait, hope springs eternal.
but
And Judge, if we're operating under that premise now, I think now they realize
I don't
They can't
think
go, they can't go.
No, I don't think they're going, from what the testimony I've heard, they're not gonna be compliant, they don't realize, I'd like to see them in Tennessee, I'd like to see them out of this county and staying down there, it'd be fine with me. But we can't send them down there and not have them supervised. So, Mr. Stockton, do you wanna make one last attempt with them to see if could you contact Tennessee and see what it will take for them to accept?
Well, they have, we're not placed, Judge, they have to have a residency, and if you look at those exhibits, that Mr. Poole and them were squatting in this estate, in this deceased person's place. They didn't have any right to be there, and so they'd have to have, before Tennessee will accept them, they'd have to have a residence down there.
Okay, what do you suggest?
Well, Ms. Poore had the shoplifting charge, and she's already pled guilty to that, besides,
Or revoke her?
that's enough to revoke her.
Okay, and
If
what
you want to.
What about that other gentleman?
Well, he had the other charge too, and he wouldn't comply with Mr. Payne. If they would comply,
Well, I don't think they're gonna comply.
that's the issue.
How about if they both get revoked, when will they be eligible for parole? That's what they need to get out from under this court here, is get on parole.
They've both got some time in because they
Yeah.
had alternative sentence from the end of the plea.
That's right.
That's right.
I don't know how much jail credit they have in, but they both have a 5-year sentence. So that's 15, they'll meet the parole board after 15%. And if they've got quite a bit of jail credit, not on Miss Poore. At sentencing, not counting her alternative sentence, Miss Poore had 209 days.
So she's almost parole eligible already.
Well, I think both of them have accomplished enough to get themselves revoked, and I think it would be in both their best interest to get revoked and see if they can get parole. Get out from under the supervision, and I would say that Tennessee's more likely to accept a parolee than a probationary. Would you agree with that?
I'm on
Yes,
the-
yes, you would agree with that.
Well, I've never seen a parolee,
Wouldn't you
but
agree
yes,
with that? Okay. You have no reason to deny that.
I have no reason to deny, it, sir.
Okay, that's- You want to just go ahead and stipulate for these two people then?
I'd rather go to rehab.
Well, that's not a choice. Yeah, I'd rather go to Tahiti too, but I don't have that choice. I gotta go back to Berkeley.
and
Well,
Judge,
to get you, I'm thinking that y'all are probably survivors and can live out there on this or that and everything, but you need to get out from under this probation, and you cannot live evidently by staying in Kentucky or staying in Tennessee, so let the parole board have a opportunity.
We got a place to go here in Kentucky. I won't do that if I don't go to jail.
I would suggest if they were revoked, and if they don't make parole pretty quick, and they got a place to come out and do in Kentucky, then they could come back and be supervised properly, and then realize that there's a consequence to not doing.
They haven't ever filed a motion for shock probation, have they?
What now? No, they have.
Well, they're not eligible. They're outside the period for shock probation.
well, they just be sitting there.
Does that start again?
He'll start, yeah, I think
It started. It
It
started when they're sitting.
it'd be Senate, so it'd start.
I think that's the best thing to do, is to go ahead and then see if they're paroled, and then you bring a motion for shock probation if they're not.
I think that's the way to go.
Okay, so that's what my ruling is gonna be. Now, as far as Mr. Birch is concerned, The problem, Mr. Burchett, is the suicide threat. I find that concerning.
And Judge, that's my concern as to
Well, we were
and
voting-
competency and another plethora of issues and. I
Well, you
feel
don't
the
have to
same-
be incompetent to commit suicide, you just need to press.
We can do an order asking that he be.
I would like to include that in the order to, it's been brought to the court's attention that there has been some state or city that he made some suicidal threats and that they be aware of that, so we can take care of that. Okay, Mr. Burchett?
Yes, Your Honor.
Okay, thank you very much. Thank both of you. And should be taken into custody. Okay, Frankie Davidson. Yeah, we didn't take that in order. Are you Frankie Davidson?
Yes,
Okay, you're here on 24CR 0038, Mr. Davidson. Were you born in 1980?
yes, sir.
The last four digits social security number, last four digits social security number 2243.
Yes, sir.
You're here today for the purpose of arraignment. You have a right to remain silent. The grand jury of Clinton County returned an indictment charging you with no registration plates, no expired registration plates, motor vehicle insurance to be in paper or electronic format, failure to maintain insurance, possession of controlled substance, first degree methamphetamine, possession of drug paraphernalia, possession of firearm by a convicted felon. Mr. Bailiff? Counselor, do you acknowledge the identity of your client receiving that will wait for more reading and arraignment, there plead not guilty, determine all pre-trial motions?
Yes, Your Honor.
Okay, I'm gonna sign a reciprocal discovery order, sir, that provides the Commonwealth provides you with evidence concerning the charges against you to help you prepare for your defense. We will schedule a negotiation date on July the 3rd, and the next court appearance here is on July the 11th. Okay. Your attorney will come over and bring you the indictment, sir, and let you discuss your defense. The next case is Charles Dickens. Oh,
Your Honor.
Charles Dickens. Yeah, did you say something? Your attorney, if you want to talk about bond, you'll need to talk to your attorney. You'll have to negotiate that with the Commonwealth attorney. I'm concerned about the charge of a firearm by a convicted felon. That's the reason they'll need to take a look at that. You'll need to talk to your attorney and talk to Commonwealth, okay?
Yes, I was trying to say that I had a broken leg, Your Honor.
Yeah. You need to talk to your attorney. You need to
Surgeon
talk-
tomorrow. So.
Okay, you need to talk to your attorney. I need to talk to Charles Dickens, please. Thank you.
It's literally just not working.
Somebody call down to the jail and see if they hang up and give us. I know it is. And we call them and see if they can disconnect you. Sign up.
We'll take action.
Commonwealth versus Charles Dickens, 24CR 0043 and 24CR 0044. This is not working. It's frozen. Can you hear me now, Mr. Dickens? No. Will somebody please call the jail and tell them to try to hook it back up again?
Get your mouse, show me first.
And the judge said you're not going to go back on the inspiration things. We're trying to do it. Wanted to go Zoom, and when you go in and log off and log back on, for it to get to me, it's fine.
Just tell them to zoom in, we've already logged.
And Zoom in, you said.
Zoom.
The judge is letting you all to, fix your Zoom because it keeps freezing up here, so you need to refresh it.
They need to log in again.
Yeah. You need to log off and then log.
No,
back
they
in.
don't need to log off. They're already logged off. They need to log in.
Right, thanks.
Be some logging going on here.
And they said they did some kind of the first time.
Ah. Email? Let's go off the record.
Kennedy Field note to another client.
Okay.
I didn't really.
Hold on, I don't need to say anything. And Judge, I have no questions for you.
What kind of program you say?
Judge, we were, officer of the state came in and presented it to, I think, the three of us about 4 months ago. It's a program, the individual has to be diversion eligible with a non-violent offense, and it's rehabilitation, but it's actually behind the fence.
It's, Judge, it's basically, he has to complete SAP IOP in a lockdown jail. He'll be like, say you had a state inmate and they completed SAP, he would be going through the same program as a state inmate, and the state pays for it.
Well, where will they send him to do
They'll
this?
send him to a facility that has SAP.
Which one, where would they?
It'll be a Class D jail. There's Hardin County does it, Laurel County does it, Harlan County does it, Pikeville
Does
does it.
Dare County do it? They've got
Dare
a class. They don't, they got a class.
It'll be out of the area, and one of the stipulations is they have to be transported by the jail, but that will get reimbursed, so,
Yeah, it's, the county's not responsible for these things,
no.
state program.
Well, I'm thinking that'd be getting this pretrial diversion done.
Then when it's completed, they will notice me, and I come in front of the court and I'll ask you all.
Mr. Gerger, I don't want you to say anything back to me. I just want to give you some unsolicited advice. Sometimes you find yourself in a no-win situation where you just have to kind of suck up and take it a little bit to get it behind you. You know what I mean? I don't know you, but you appear to me to be troubled by all this. It's on your mind and troubled. So I'm gonna give you a chance. Okay, I'm gonna give you a chance to try this new thing, but really work real hard on it. If somebody says something to you that offends you or make you mad, you just take 5 seconds and just think, do I want to just go on and get this behind me? Now, that doesn't mean that you shouldn't defend yourself if someone does something physically to you or something like that. I'm gonna go ahead and sign the order and try it. If this works for you, you might be one of the people that tries something out that help other people too. I think you obviously got a drug problem, and it's not easy. If it was easy to get off that stuff, everybody would, wouldn't they? They just say, I believe I'm gonna get off that. It's not easy. So,
Thank you, Your Honor.
yeah, I'm gonna do that, and I hope that you, and while you're there, if, I can't tell you what to do, but if they've got any kind of Bible study or anything like that, it wouldn't hurt you to be around some good people that have also got problems, okay?
Okay, thank you.
Okay, good luck to you, Mr. Gordon.
It's not really my accreditation, but it's very piece.
Okay, Brian Gross. Commonwealth versus Brian Gross, 24 CR 0041 and 24 CR 0031. I had to look up the clock, Mr. Gross, see if I was going to greet you with good morning or good afternoon, but we're still in the morning. Good morning to you.
Good morning.
You're here today were you born in 1985?
Yes, sir.
The last 4 digits, social security number 2218.
Yes, sir.
Okay, you're here today for the purpose of arraignment. You have a lawyer here. If you have any questions about what's going on, step away and ask him. Okay, the grand jury of Clinton County has returned an indictment in 41, which was 23F 00104, charging possession of handgun by a convicted felon. And what was the other? It looked like there was 31. We already been arraigned on 31. And clerk.
I think that is the case, Judge. I think maybe
This is
31.
41.
No, he's right on the
Okay, we got 31. This is 41 I just did. You acknowledge the identity of your client receiving not away formal reading and pleading not guilty of serving out the trial much until 41. I need 31 now.
Yes, Your Honor.
If you want to do the negotiation, then we could step down about the sheriff.
What are you doing? What is it? Okay, this is in 24 CR 30. The grand jury of Frank County return an indictment charging you with possession of controlled substance of first degree. You acknowledge the identity of your client received the indictments, waive formal reading and arraignment, enter plea not guilty, reserving all your pretrial motion.
Yes, Your
Now,
Honor.
Mr. Stockton, are these a common occurrence, or are these two completely separate things? You want to merge these, or?
I think, and there's another case coming from the grand jury today, so.
Well, let's just wait and see on that. And we go ahead and set him a negotiation date on the 3rd in Cumberland County.
Yes,
3rd of
Judge.
July, and then he'll be arraigned on those new charges and try to roll everything up on the 3rd, and maybe we can take care of it on the 11th.
That's what the Commonwealth.
But now we've got a handgun thing here, Mr. Stockton. You know how I feel about that.
I know, Your Honor.
Well, Judge,
Well, y'all just need to work. on
Exactly,
it.
yeah.
I'm just putting you on notice that something needs to be done about it.
I understand.
Okay. Okay, thank you very much. Brian Markham.
And Judge, this is a hearing. We can take it now, or if you wanted to take this up last, I don't want to keep Mr. Cross and Mr. Wittenberg waiting.
We'll just do it.
Okay.
Commonwealth versus Brian Markham, 23-0050. So a motion to set aside is all the need to vacate. Is that what it is?
That's correct, Judge.
Go ahead, present.
Judge, my main basis of that is, with our jury verdict, the jury reached a verdict of cultivation more than 5 plants.
Yeah.
I filed a motion in limine, obviously challenging the admissibility of the of the marijuana that was in the truck.
You said the lab had made findings on each one of the plants, right?
That's correct, Judge. And the issue, and as the lab examiner testified, when they typically have cultivation of more than 5 plants, there's more than 5 samples sent, so that can be testified to. In this case, with the labs, there was 2 samples sent, none of which from the truck. That's my concern.
Your client make a statement, though, that he was growing marijuana to support his other habit.
And Judge, I'm not challenging, and my issue is with trafficking. It's with cultivation, and Judge, the case law is clear that when you have marijuana and you're using sampling, that the sampling has to be in the same nature, the same characteristics, the same appearance. Here we have 3 distinctly different alleged marijuana plants. We had some that had been harvested. We had some that was in a tray. We had some that was a plant that was presumably grown. The only thing that was tested at the lab was the plant that was grown. So to impute the marijuana onto all 3 samples, Judge, goes against Kentucky law.
Your interpretation. Mr. Stockton, what do you have to say about that?
Well, Your Honor, I would disagree. And the reason I would disagree is that each officer that testified that it marijuana that they found. Mr. Markham admitted that it was marijuana and it was his marijuana. The lab, the samples that was sent was marijuana, and there's no evidence in the record that it was not marijuana. There was not one bit of evidence that it was marijuana. So I don't know how we can even sit here today and say it wasn't marijuana. Because everybody that testified, and even the defendant's own admission said it was
Are you
marijuana.
saying if there were 6 plants and you were prosecuted at 5 or more, that each one of the 5 had to be tested? Is that what you're saying? I'm just asking.
That's what the lab technician testified to.
He didn't testify.
He said that was their normal.
That was their normal practice, and Judge,
He didn't say that was.
what he also testified to is the sample that he tested was more hemp then it was marijuana. That was the testimony,
You're just
Judge.
characterizing his testimony. His testimony was that it was not sent off for quantitative analysis. And you made that argument in front of the jury, and I said, well, there was no evidence that there was any industrial hemp production going on that it needed to be differentiated.
And Judge, if that being the case, then what that signifies, and the testimony was more hemp than marijuana,
I
then
don't think it said more hemp than marijuana.
I think the technician was very confused, but I do, but he,
You got him pretty confused. I'll give
that's
you-
my
I'll
department, he
correct
did a
you.
great job, but Judge,
Here's the thing about it. You know, in a few years, this might be legal, who knows, but it's not now. And I would take judicial notice of the fact that I have seen marijuana grown illegally for years and years and years. I even represented some people that were accused. Some of them got convicted, some, but I never in all that time saw anybody that would grow or allow anybody to grow some industrial hemp around their marijuana plants because it would cross pollinate and take the quality of it down. So it's an incredulous argument of the fact that anybody would have industrial hemp around any marijuana that he admitted he was growing. So it went in front of the jury. He decided, he was the one that decided he wanted a jury trial. You know, and this is the verdict he got, and I think there was more than ample evidence. So I'll make you some findings on this thing and deny your motion, okay? Now, have you had an opportunity to go over the sentencing document with him?
I have to,
Then Mr. Pennington, Mr. Markham, you come around on this other side. Now, Mr. Pennington undoubtedly is going to appeal your case, which is your right to do that, okay? But I'm going to go ahead and do the sentence. A jury of your peers found you guilty of cultivation of marijuana, 5 or more plants, and gave you 5 years, and then they PFO'd you, PFO to the second degree and enhanced it to 10 years. There was possession of drug paraphernalia for 12 months and possession of marijuana for 12 months. And those obviously go in and or are extinguished with the felony plea. They run at the same time. There are 2 $500 fines. I'm going to waive those $500 fines. I'm going to waive your court costs because of the length of your penalty. This is a final and appealable order, and we'll try to get you something written on your motion to alter and to vacate, okay?
Thanks, Your Honor.
Thank you very much. Daniel Norris. Commonwealth of Kentucky versus Daniel Norris, 24 CR 0046, 24 CR 0060, 24 CR 0030, and 24 CR 0029. Mr. Norris, were you born in 1996? The last 4 digits of social security number 1043. Okay. I'm going to arraign you. Your attorney's there. You have a right to remain silent. The grand jury of Clinton County has returned an indictment charging you in 0040 with burglary in the 3rd degree, criminal mischief in the 1st degree, and theft by unlawful taking. Do you understand what those charges are? Okay. I'm going to sign a reciprocal discovery order on those. Where's the other indictment? Here's the other indictment. The other indictment, which is enumerated 46, you've been charged with escape in the 2nd degree, fleeing or evading a police officer, assault in the 3rd degree, and resisting arrest. And you're alleged that you took a swing at Sheriff Ricky Martin with a coke can. Well, I'm not saying whether you did it or not. It's what it's alleged. And if you did do that, I'm sure you're lucky it didn't turn out any worse than to do it. So, okay. You acknowledge the identity of your client received indictment, waive formal reading and arraignment, enter plea of not guilty or serving all pretrial motions.
yes, Your Honor.
Okay, let's set a negotiation day for all of his cases.
Judge, if I may actually.
Oh, go ahead.
Judge, the Commonwealth has agreed to allow Mr. Norris to undergo a KCPC evaluation. So now that all the cases have festered together.
Okay, well, you get me an order on that.
I think it's already been tendered, Judge.
Electronic
It's
sign.
already did.
It's already in, okay.
Do you want to set that pre-trial out so it's a long?
Let's set the pretrial for August the 8th. Okay, Wesley Rains. Commonwealth versus Wesley Rains. 21 CR 0028, 22 CR 0065, 22 CR 0066. Motion for shock probation. Go ahead.
No, so motion to vote.
Well, it's got shock probation adopted. I'll just change.
Well, I'll take that. That's fine.
Motion to revoke. Was he previously shock probation?
He was.
Yeah, okay.
In this case, he's charged with being in possession of a firearm, a convicted felon, basically hunting turkey out of season and killing a turkey. And according to Officer Cotton Game, he admitted to doing that with a 20-gauge shotgun. And if we need to have a hearing, I'll need to get another date since the officer was available. But,
Your Honor, in response, I think we do need to get another date because
Okay, we'll have to set a hearing on July the 11th.
Your Honor, as Mr. Stockton has set forth to the court what the true circumstances are about this case, would the court consider allowing Mr.
Well,
Raines?
are you willing to stipulate as to what the circumstances? You're challenging what the circumstances.
Well, it's just, I'm not going to stipulate revocation. I'm going to
Are you
agree
going to
with,
stipulate that he had a weapon?
I'm going to
What
agree.
you're gonna do is want me
He
to
had a-
nullify. I've heard your
He-
statements before.
He had a
about-
weapon in his possession and he was turkey hunting.
Yeah, he's in trouble.
I know that. That's why I
So
want
we'll
to call
set on
Mr.
July
Payne and everybody
the
else that
11th.
we can.
Have a hearing on July the 11th.
Your
I
Honor,
know it's your position that the people in Clinton County that are convicted felons ignore the law. You say.
well, Your Honor, when you live in the country and it's crossroad from your house and somebody says, let's just go down there and go turkey hunting.
And if, and then nobody sees you, all right.
Yeah.
But if you get caught, I'm fixing to send you to penitentiary.
That being
If
said,
that's true.
will the court, he works at Dale Olive Charcoal, has a good job.
July the
Consider work
11th.
release.
We'll-
Clean down.
July the 11th, and if the circumstances are there, this time that he serves, he might do him well, you know what I mean, get it behind him.
Thank you.
Okay, thank you. Cody Smith. Cody Smith. Commonwealth Kentucky versus Mr. Smith. You'll be the last person I get to say good morning to because you got 3 minutes. Good morning.
Good morning. How you doing?
This is 23 CR 0067 Commonwealth versus Cody Smith. Mr. Smith, were you born in 1992?
Yes, Your Honor.
Last 4 digits of social security number are 4867. We're here on a, what are they?
4267.
42, got another wrong, social security number 4267. Okay, we have a plea in this agreement. It looks like you're kind of coming up on the edge there.
Yes, Your Honor, it's a diversion, but
Yeah,
There was one question, Your Honor, and I put this up with Mr. Stockton, and he told me to, I guess, ask you. He's got 90 days to serve, in addition to contempt time. How much contempt time are you giving him? He failed a drug test. It's what got him originally in, it's a bond violation.
he can enter a plea and then we'll address that. I'm usually fairly liberal about those sort of things. That's all. Is this a felony plea?
It is, Your Honor.
It's a diversion.
yeah.
I forgot. That was the HNC record.
A motion has been tendered, sir, that says you wish to enter a plea today. Is that correct?
Yes, Your
Are
Honor.
you currently under the influence of drugs or alcohol?
Absolutely.
Is this plea freely and voluntarily given? Are you the same person named in indictment number 23 CR 0067? Is your judgment impaired today in any way? Have you discussed this matter with your attorney? Are you satisfied with his advice? Have you viewed the information and evidence the Commonwealth has against you? You believe you're fully informed about your case?
Yes, Your Honor.
You understand that you do not have to enter guilty plea. You have certain rights under Kentucky United States Constitution. Before I accept the plea, I need to know that you fully understand those rights. You have a right not to testify against yourself. No one can make you say anything. Right to speak trial by jury, right to be represented by counsel at your jury trial. The right to confront and cross-examine all witnesses called to testify against you, right to give evidence, right to call witnesses in your favor, right to appeal this matter to higher court. If you lose, the right to probably come up, prove beyond a reasonable doubt that you're guilty charged against you, understand that being a guilty plea. So I need to take a quick break here. I'll be right back and finish this, okay?
I think I'm right too. It's pretty hot.
Don't get some flip flops like that when you get out.
I might, actually, I got pretty used to it. You know, I get off a lot higher and run a lot faster. But I ain't gonna use, I mean, they trying to build a new testimony, jail. You know what I mean? Okay. They are tough, I can say that. I had one that was actually shoe size bigger for about the first month I was there.
I saw somebody that's 2 or 3 times too big.
All those are your swimming slippers, there, you know?
It's not there.
We'd rather bear it. That's in the arm, because we figured they'll take our boots, we're gonna have to. Yeah. So we have to have that rare thing. Cross the road there. Really, that's all.
It's not even.
Rock and walk on glass.
I'm a baby without shoes, the pain of shoes on, because you know,
He can usually always do it.
Okay, let's go back on the record when we resume. By entering guilty plea today, you give up the rights that I just read to you. Now, I may consider the Commonwealth's recommendation, but I may apply a range of sentences allowed by law. In the event that I do not accept the Commonwealth's recommendation, you decide to impose a harsher sentence, you have the right to withdraw your guilty plea and proceed to trial. I'm going to ask you some qualifying questions, okay? Have you previously been diverted in the last 5 years? Pretrial diversion in the last 5 years?
right before this case, I believe, I just had completed my diversion.
Okay,
So I completed it, it's been.
okay, Mr. Stockton.
That must have been in district court.
Yeah, that was.
They wouldn't need felony, John.
It was.
And they call diversions in district court. I don't think there's any statutory authority to diversion in district court. That's my opinion. So I don't think he's violating the statute for energies.
Have you had any felonies in the last 10 years?
No.
You understand if you fully complete the diversion agreement, the charges will be dismissed, pretrial diversion, get your record expunged.
Yes, John.
You understand that if you do not fully complete the diversion, you will be brought back before this court and can decide to schedule a sentencing hearing. You understand that?
Yes,
You're not be convicted felon. If you move over your left here, all the way to your left. Move on the way to the left here. Okay, now, Ms. Gordon Anderson, will you read what the offer is?
Yes, Your Honor. Upon a plea of guilty to wanton endangerment first degree, the defendant shall receive a sentence of 5 years. Upon a plea of guilty to intimidating a participant in the legal process, the defendant shall receive a sentence of 5 years. The 2 5-year sentences shall run consecutively for a total of 10 years, serve 90 days in jail with the balance pretrial diverted for 5 years supervised. The 90 days incarceration shall be in addition to the contempt time. The defendant shall receive credit for time served, but shall not receive credit for contempt time. The defendant shall enter and complete a minimum 6 month long-term treatment facility scheduled through counsel and subject to the approval of the Commonwealth. The defendant shall serve 90 days of incarceration first and then be released to the treatment facility the morning of bed date. The defendant shall be transported by probation and parole to the treatment facility. The defendant is currently under a no contact order through district court. The no contact shall remain. Any and all future contact shall be in accordance with the orders of the Clinton District Court. Defendant shall obtain gainful employment or do a minimum hours of community service per week until gainful employment is obtained. The defendant agrees to have any and all evidence in the above style cases disposed of in a manner with the laws of the Commonwealth and the holding agency.
Sir, is that your understanding of the Commonwealth's recommendation?
Yes, Your Honor.
Okay, is anyone including your attorney offered you anything else to enter this plea? Or are you entering this plea because you didn't commit the acts as charged in the amendment indictment? Yeah, you know your own free will, know your constitutional rights that I've explained, is it still your desire to give up those rights in a plea of guilty and allow the court to fix the punishment in the range permitted by law?
Yes, Your Honor.
Okay, is that your signature on the document there?
Yes, Your Honor.
Okay, I'll accept the agreement and sign the diversion. Now, how many days does he have in? You know, probation, bro?
I do not, where he's pretrial diversion. We haven't done anything. I know he was lodged.
He was lodged on a contempt.
Yes,
How many days?
on April.
April 11th. April 11th, Your Honor.
Judge, I would have to do some figuring.
Okay, we'll do some figuring on the thing and see when it's revoked.
Does he get credit?
Not really.
But does he get credit for the contempt time?
It says in the agreement that he does not.
Okay, he does not. Okay.
Yeah. But how many days of contempt did I give him? Does it say?
You didn't say, you just held him contempt.
I didn't say. So how many days has he been in? How many days?
Yeah, I think 66 days. If I'm not mistaken.
Mr. Stockton, I'm inclined to split the difference with him.
That's okay.
Okay, I'll just,
He has, as of today, since not counting the time that he had before he was put on contempt, I'll have to figure that when I can sit down and pull the records. But he had 63 days of contempt.
no,
Yeah, he's been in for 60.
he's been in for 63, but that doesn't necessarily mean he's
No.
been in for 63 for contempt.
He's been in 63 since April the 11th.
Yeah, I understand what you're
Yes,
saying.
yes.
What I want to know is how many days before that?
If you'll give me just a second, I can see if I can find it.
Yeah, but it is for 63. Yeah, but I'll be sorry.
Give me just a second, Judge.
I don't think so. I'm not sure.
And he was going to sit,
He may bond the same day he was served.
so he was going to serve 90 days after the contempt, is that what it is?
Yes.
Okay, what I'm gonna do is, I'm gonna give him 63 days, 33 days for contempt and give him 30 days credit. So he'll serve 60 more days. That'll split the difference with you to be out in 60 days, and then you go to the treatment center for that, okay? Okay. Here you go. What is it? Yeah, it's a pretrial version. Okay, Michael Taylor. We did. Yeah, he was on the other docket, yeah. Lloyd Owens.
This is an thing.
Commonwealth versus Lloyd Owens. 24 CR 0004. Are you Lloyd Owens? Born in 1959. Last 4 digits social security number 8020. It says here, pretrial conference and motion to revoke bond. What does the Commonwealth have to say on this? Mr. Stockton?
Yes, Your Honor.
It's a motion to revoke bond, is it, in pretrial conference?
Yes, Mr. Owens allegedly violated his EPO, DVO by sending his sister some rather bad text messages, and she's here to testify if necessary. Otherwise, I just ask he be held without bond until we either reach a resolution or set a trial date.
What's he charged with?
He's charged with 2 counts of wanton endangerment, pointing a gun at each sister on 2 different occasions. Yeah, and then so
What do you have to say?
Your Honor, we're not in a position to oppose the bond revocation motion today.
When do you want to schedule anyway?
Well, we can do it July 3rd at 1 o'clock, if you want to do.
Let's do negotiation on July 30 at 1 o'clock. His next court date will be July the 11th, and I will revoke the bond. And he'll be held without bond for violating the court's order, and if you get it resolved on the 3rd and the 11th, move on.
Thank you, Your Honor.
Okay, now, are you going to move this Michael Taylor up here, or is he not gonna come at all?
No, he's not, and that's what Mr. Cross talked about, the agreed order, if he can do the bank.
Okay, so does that include the docket?
As far as I know, yeah.
Okay, well, hallelujah. Okay, let's go off the record.
Megan, what happens to do?
to the border. Call it child support docket.
Good afternoon.
Mr. Raines in Omaha, on the way to Omaha.
Well, he was, Mayberry Monday, I think it was. Where's that today, do you know?
Neurologist today.
Neurologist, okay.
So
Doctor.
Doctor.
Carol versus blank.
Read order, Your Honor. That done.
Cabinet versus Polston.
Read order, I believe they said. You have to speak up to me now.
Okay.
Is this person here? It's over against Christopher.
Brown versus Brown.
Christopher Brown. Your Honor, this is a request for a contempt order. $430 a month is his current support. His balance owed is $1,275.81. They're asking to pay $900 by July the 10th to purge.
Morris versus Morris.
He's here. He's coming. He's in the green. You see your order.
Okay. Are you Dale Edwards Marsh Jr.? What do you got here?
This case, Your Honor, his current support is $351.78, plus $50 a month on arrears. He owes $1,908.10. We're asking he paid $500 on or before July 10th, 2024, so that he can be purged of contempt. That's what we're asking. What is your response?
Currently, my financial situation won't allow that, Your Honor. By the time I get my check, child support coming out, I barely make it. My significant other
Let
has
him, wait
to.
a second, let him, y'all move over.
That way you can be heard.
You move over, you move over.
Okay.
Raise your right hand, you swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth.
Yes, Your
Now,
Honor.
the county attorney's office asked you if you could make the payment they suggested. Where do you work?
I work at Burger King,
Okay, and how much you make at Burger King?
$10 an hour.
Okay, and you say there's child support already coming out of that?
Yeah, here and from another child in Lancaster County, Nebraska, which is $800 a month on that one child. So,
Yeah.
yeah. And my rent is weekly payment. It's $150 a week.
Okay, well, have you ever thought about getting a different job?
I had two jobs. I did, and Major's Pizza was my second job to help, but they cut me down to 8 hours a week.
Yeah.
And it wasn't helping. So I decided to pull a little bit more hours at Burger King and go for a management position to increase, the pay.
And that didn't work?
And it's not helping. To
You're-
see
you're
what the child.
Management position, just get $10. Did you get the management position?
It's only $1 raise, Your Honor. Now, if I may explain, when I get my check from Burger King, it's usually between 140 to 150 a week. After child support and everything comes out, my weekly rent at where I live is $150 a week. So sometimes I don't make it. My significant other has to make up for that just so that I can keep my room, which leaves me with no money to buy food, personal supplies, pay my car payment, pay my car insurance. The bank's gonna repossess the vehicle. They've already sued me for over $18,000 on that. So that's where I stand.
I'd ask the worker some questions. Is it okay?
Yes.
You raise your right hand, please, for a testimony you're about to give us the truth over.
Yes.
Go ahead.
This is just one question, since I don't know about the case as much as Mr. Raines would. Did the support worksheet take into account the other child? How does that work?
No, this child is the oldest, the other child out of state. This is the oldest child, and we're not allowed to count like the other child.
Have you communicated?
So the child out west is a subsequent child.
Yes, but he is paying a lot more out there in the other state.
And
He's
you-
got paperwork on.
So you have paperwork on
He
that?
does, yes. We can't see anything out of state.
Are you allowed to communicate?
Yes,
with out-of-state folks?
We can.
Well, there's no relevance into what he's paying out there because he doesn't get any credit here if he's got, the oldest child gets the preference and the oldest child is here, so it doesn't really matter what he's doing out there. If he didn't pay anything, I would suggest that not paying out there would probably serve him better here. Because they would have to indict him and extradite him if he go out there, you know, see what I'm saying? I just don't see how he can make it the way it is, you know, but that doesn't mean he doesn't have the obligation to do it. Sometimes you have an obligation, and when it accrues to a certain amount, sir, they can get a criminal indictment against you for failure to pay child support and send you to the penitentiary.
Well, they are pulling from my Burger King check out there. That's why it's so.
I'm talking about here.
Yeah.
Well, I know, but did you sign a wage assignment out there? You bound to sign a wage?
No, I was hitting the paperwork after I moved back. I haven't, that's a 14-hour ride out there.
Well,
They haven't sent me anything other
if
than.
they're withdrawing from his wages here, there has to be a wage assignment or a judgment domesticated. Y'all domesticate a judgment?
We did a wage assignment for this case.
You did what?
A wage assignment on this.
For this case, but how about the one out there?
I'm assuming they probably did. Other state.
Well, I mean, but he'd have to agree to a wage assignment or they'd have to bring that judgment here and get it domesticated. Isn't that right, Mr. Little? They'd have to take that judgment here under a uniform reciprocal act. Get it recognized, and y'all would probably be involved in that too, wouldn't you? The other states in there, they send them directly to people.
They will send it directly to the
Employer?
the employer will send it to the state and the state will direct it to the mother.
Yeah.
Yes.
What do you suggest?
Well, if I'd suggested to him, I would get an attorney to look at their calculations. On, you know, and that out of state one here, there's not a lot we can do. You know, I would suggest that this is my suggestion.
What's he paying now with the current obligation here and the arrearages?
378 a month.
That includes the arrears is $351.78 a
That's
month.
just current.
That's the current.
And then 50 on arrears.
50 on the arrears. And he's got behind on that, is that correct?
Has he been paying nothing?
No, they're waging his check.
They're-
from
they're
Burger
taking
King. They're mailing it in. for
Are you
him
getting the arrearage amount also
when he gets stuff out?
when he gets enough hours? Are you always getting the current amount or not?
Most of the time.
Most of the time.
He has asked for a modification and our office is checking into that.
Well, let's put it off for a month
That's
and
okay.
take a look at the modification. You've got to find a different job. The problem is when you get a different job, and see if I'm looking at this right, when he gets a different job, the child support obligation will raise too. So he's caught between a rock and a hard place, correct?
Yes.
All I can suggest to you is gonna have to work on that other case that we have no power to help you with.
How much is it a month out there?
$7.95.
But you know, I don't see how that could be right. Their
Yes.
income level. But they might be finding that you're voluntarily underemployed too. People do that on occasion. So we'll see, you dock it back up, work with the county attorneys and dock it back up and be back here on July the 11th.
You know, I have a reason to believe why it's so high out there. The job that she gave them, I no longer had. I was making nearly $2,000 a week.
Well, and they
And
think
then
that
when
you're
I
under,
changed jobs,
they
they
think
got-
you're underemployed, that you're intentionally. Well, I'm speculating, but it's neither here or there to me. It's not my business.
They have the new work appointment though. And it's.
Let me tell you what, brother, if you're making $2,000 a week or whatever you were making, and all of a sudden you start making $2, $10 an hour, people get suspicious of it. You know, that people are voluntarily underemployed, not, so they won't have to meet their obligation. And the county attorney's office doesn't frequently do that, but I know y'all have done that. When you look at somebody and they say they got qualification to do more, and all of a sudden they go from $100,000 a year to a minimum wage, then they get suspicious of it. So, okay, we'll work with them and see what they can work out. And, you know, I will tell you this, it would appear to me that any kind of wage assignment that we have ought to have priority over an out-of-state wage assignment. So I would take a look, because they can just get a certain percentage of his income. And it looks like they're pushing the edge of that. Am I right or wrong? So check with the employer and see if they're giving precedent to our wage assignment versus the out-of-state judgment, and see if they're doing it, because they don't know how to calculate that. So most employers don't. They don't. It's a wonder they let you keep working, but having to fool with these wage assignments, except they can't get anybody to work anyway. Nobody works, so you're committed for continue to work. So you'll be back here on July the 11th, work with the county attorney's office, okay?
At what time?
Okay. So 1 o'clock or soon thereafter, you can be heard, okay? Okay, and go meet with them next week sometime, okay? Okay, McGall versus Barber. McGall versus Barber.
They wish to pass it, Your Honor, the respondent is hiring an attorney, so we will, a private attorney, we will reschedule that.
Cabinet versus Claywell.
This is paternity only, Claywell is incarcerated, and this is a request based upon a test with a probability of paternity of 99.9%, Your Honor.
Did he file an answer?
No.
What do we do when someone's incarcerated? Do they need to have a guardian? What do you usually do? Did you look at the file? Did you pull a file out and see if he's filed an answer?
This is just paternity only.
Paternity only. Was he served, was he incarcerated when he was served, I guess is my question.
Yeah, I think so. He's been incarcerated. He submitted to the test.
He submitted the test involuntarily? Okay.
It's a state, yeah.
This is purer than ivory soap. Okay. Lower versus lower.
Both parties, this is both parties.
Okay, what do we have here? We have Mr. Jonathan Lower, is that right? Yeah. And Miss Ashley.
The child support office states that the order was $782 a month current support and $156 a month on arrears. The current balance is $2,220.50. Support office is asking for $1,100 by July 10th.
Does that include, is that just out of the arrears that you're asking, or is it on top? Let's say it's, what's he paying now?
There's current support obligation, correct? The current support obligation is $782 a month.
Okay, and what's the arrear? Additional arrear, didn't you say it was 50 something?
$156 a month.
Is that what he's doing now?
So, the arrearage amount then is.
No, I want to know, is he paying toward arrearages now?
No, he's not
So
making
the
it.
782 is current support payment, doesn't include arrears. How far is he behind?
2,220.50.
So he's about 3 payments behind. About 3 payments behind. And you're suggesting what the arrears are?
156 a month.
On top of that, you want him to pay about $900 and something a month, is that right?
Yeah.
Right. We want him to pay $1,100 by July 10th. That's.
What does the 1,100 stand for? So I was saying.
That if he paid the 1,100, 782 would go towards his July current. So he would just be making a little over that towards his arrearage balance.
Well, I'd like for you to pay the $782 plus 10% of the arrearage. That gets him down to something under $900, which you might be able to do.
With my financial right now,
Well, you want to be smart about your financial situation, move to your right there. You raise your right hand, you swear the testimony about to give us the truth, whole truth, nothing but the truth.
yes,
Okay, what's your name, sir?
Jonathan Lauer,
Where do you work?
Nathan Thrasher,
Yeah. And you're mowing lawns?
my what?
You doing lawns or what are you doing? Yeah. What do you make?
I get $10 an hour.
Yeah.
And the child support was based on $16.50 an hour, and I put in for a review.
It was denied last month.
Denied, I have to ask her what you mean.
It was an underemployment situation, is that correct?
Possibly, but
Was there a hearing last month?
yes, the non-petition was denied.
Yeah. Well, I would suggest that you give him a date to pay 10% on top of the present for arrearages, and he pay those arrearages.
Can you amend the order? Okay.
That, so, and if you pay the arrearage, 10% on the arrearage in 10 months, you'd be caught up. And that way we wouldn't get you an amount, $1,100 for you to pay that you can't pay and you'd have to go to jail. I want you to keep working, but you might have to find a different job. I mean, you can't $10 an hour.
Well, I helped Brad Cross in between when I ended up with Nathan, try to help pay, but I just took a payment up there yesterday. I pay what I can.
Well, you're gonna have to pay what you're ordered to, and not just what you can. You know, that's just a decision you'll have to make.
I make $10 an hour too, but I still see that every kids are taken care of.
Well, I'm not suggesting anything other, I'm saying he's got an
I know.
obligation.
I'm just saying.
Yeah.
I mean, I've got an apartment I'm getting ready to get out of, but I can't even pay it.
Well, there's nothing I can do about it. There's the orders and I have to enforce them, you know, the orders are in place. So, reduce it to his current payment plus 10% till the arrearages are paid. And the first when's the next payment due?
July 1st.
Okay, so you need to pay the July 1st payment by July the 5th plus 10%.
Will be how much?
800 and something, right?
Yes.
By the first?
No, by the 5th, that's it,
All right.
by the 5th.
I mean, I'll try. I mean,
Well, if you don't, you're going to jail.
okay.
Okay, and that doesn't do anybody any good, your kids or anybody else, but I don't have any other choice. There's no other choice. I reduced it from what they suggested, so enter an order to that amount, and he can purge himself if he pays that amount before July 5th, and after that, that amount will be that amount for 10 months, and then it'll lower back down to what the regular payment is right now. And I would suggest that you might lawyer up to see if you can prove that the amount's too high as far as the regular child support. How many children are there? Two? Three children, huh?
I want to fix and turn 18.
Yeah, well, so y'all will roll that back off then. When little boy, little girl?
Girl.
Girl should be 18 when?
July.
Well,
June 26th.
that'll roll one of them back off, and then you can do a reduction of that, and then he can still do his 10% on the arrearages, okay? Okay, thank you very much. Cabinet versus Kilburn.
This individual made a payment, we'd asked it be passed.
I'll get this and do it. Thank you, Dustin. Orton versus Orton.
We have an agreed order, Your Honor.
Okay.
He's here. Yes, you
Cabinet versus, Andra.
Anaya, I think I pronounced it correct. Juan Anaya, if you would come up here, please.
What do we have here?
Your Honor, this is a foster care case, am I correct? And the, current support is $85 a month. The balance owed now is $286.52. We're asking, Ms. Tenaya to pay $200 by July 10th, and keep making his payments to remain out of contempt.
So he pays 200 by July 10th to purge himself.
Yeah.
And then he makes his regular payments after that.
Yes,
If you don't pay that by July 10th, you go to jail. Understand? So, okay, thank you very much. Virtue. Happy. Same, second.
if any of the parties here on this one.
Virtue.
Right here on Burchett, this is a grandfather custodian receiving public assistance on children. And we're asking the $312 per month current support and $62 towards arrears to begin.
What is the relationship here? Explain this to me.
Grandfather has custody of his grandchildren and the daughter is the respondent. He's drawing state assistance.
And so they're asking for the daughter to pay and they want her, did she come in to be interviewed on her income or that?
No,
sort of
we based it on minimum wage.
thing?
We've not
Wage,
heard-
okay, I'll sign it.
Thank you. This is. Okay. Wait. Oh, this is agreed.
Is it Britt now? I'm more person, cabinet versus Britt, what's the second?
Agreed order by judge. Yeah, you're right. Came and signed something. At the office, okay. Sometime after this was broken.
Tucker,
Which one?
cabinet versus Tucker.
Again, this person's incarcerated, so we're just asking him to notify us when he is not incarcerated, so there's nothing else here to be ordered. Which one is that? Oh, this, okay. Is that? Let me give you a present.
Is that it? Thank you all very much.
Thank you. I don't know.
5 minutes to the 1:30 docket, let's go on to there. Hello, can you identify yourself, please?
Shauna
And you're Jonathan?
Jonathan.
Okay. And the biological mother is Patricia?
Yes, sir.
Well, you filed a motion here that says that you have joint custody now, but it's just an emergency custody because she never did come back.
No.
And contested, is that right? You say she
Yeah.
lives somewhere in Grayson County. The last time that we entered a judgment in this case, however, we appointed a warning on her attorney to make sure she had notice of the fact that there was going to be some change. I know that you've made some statements in your motion as to the present condition as far as addiction or that sort of thing. But I'm uncomfortable signing any order in this case until we get her back in front of the court in some way, or at least give her notice. So I'm gonna have the clerk's office appoint a warning order attorney to give notice on her to make sure that she knows that this is pending. Technically, she's still in front of the court because she's been served previously by a warning order attorney. But I'm gonna use that again to let her know that this will be heard at 1:30 on July the 11th. Now, I won't go into your health problems that you have. But the thing that would be most certain right now would be for you to just pass this and just continue. You want this because the government benefits are coming to you instead?
No. The only thing is, I've got to have a heart surgery again,
Yeah,
and they're not giving, I've got a massive hole in my heart now.
yeah.
And
I don't want to
to.
embarrass you by talking about your
Yeah.
health problems, but right now, who gets the benefits for the
I do.
children? You do. So you want to make sure that if something happens to you, that your son can
Yes.
manage. And that's what I was getting to. I wasn't insinuating
Yeah.
anybody was trying to take the benefits.
Yeah.
So can you do that with the cabinet without getting an order, or do they say you need to have an order?
No, we could probably do it that way. I just,
I would suggest that rather than to modify this right now, I would suggest that you think about it a little bit and go down and meet with the cabinet and see if they can go ahead and make that transfer.
Okay.
And both of you still have the joint custody. You can have this joint temporary custody, and you can do what you need to do that way.
okay,
So I'll just hold off for a little while, and after you talk to them about if you need to do something, I can redocket it. And you can come here to the clerk's office and get our phone number and tell us that you want a warning order attorney appointed. And it could be that she's in jail or somewhere else, and if she is, we might have to take some other step. I don't know where the mother is. So if you'll do that, think about it, and meet with the cabinet and call the clerk's office here if you want a warning order attorney or someone to notify her that this is pending. She probably won't come back. She hadn't come back up to this point, but.
yeah,
Okay?
all right,
Okay,
thank you.
thank y'all very much. I hope your health issues resolve themselves.
Thank you.
Yeah. Sandal versus Longwell.
Good afternoon, Your Honor.
Hello.
Larry Shelton, I represent Mr. Sandal, who's also present for the motion.
Yeah. And this is a claim of $4,756 or something like that. You
Yes,
want a judgment and order of sale. Where is the defendant not filed an answer? It says it hasn't.
No, he contacted me,
Yeah.
and spoke to me, said he was hiring legal counsel. This has been approximately a month ago, and that they would reach out to me, and still no contact.
I'm willing to do is this a piece of property that was sold by Mr. Sandal to Mr. Longwell? Where did this?
This was, I don't know if you recall this,
I don't.
we were in front of you. There was a dispute on the claims of there were two separate deeds to this property.
Yeah,
And there was back taxes owed on a portion of it, and he was paying his taxes, and then the other judge ruled first one to file, obviously, so it got away from that claim. So he'd already had all the SPAC purchases that he'd like to be reimbursed for. And we forego any of the other
but
improvements
it
and so
appears
forth.
to me that you're maybe entitled to a judgment, but not necessarily an order of sale yet. You know
Yes,
what I
sir.
mean?
Yes, I understand.
Yeah, so let's just submit a judgment, a default judgment, is what
Okay.
you're asking for.
Okay,
Submit a default judgment and file a default judgment to protect this gentleman's interest.
okay,
And then once you get that, if the gentleman does not pay you to execute on other things necessarily before you with this particular piece of property, you know, personality and that sort of thing.
Yes, sir.
Okay, thank you very much.
Thank you, Your Honor.
You can electronically file that with us and we'll do it.
Okay, thank you, Your Honor. May I have the excuse?
Absolutely, thank you. Zachary Appleby versus Deborah Lynn June Johnson. Motion to intervene, motion for custody, motion for supervised visitation. Okay,
We have no objection to the motion to intervene on behalf of the petitioner, Your Honor.
okay, now, who are you?
I'm the mother, I'm Deborah.
Who represents you, Mr. Croft?
No,
Who represents you? You have an attorney here?
no.
Okay, now, this lady, ma'am, how are you involved in this?
I am the great grandmother of her daughter.
And she's the one that I filed the motion to intervene on behalf of Judge.
And nobody objects to that. Okay, so we'll sign an order to intervene.
I
Now,
think there's a district court order.
There is a district court order that's in place right now where she has custody. It's my understanding the parents are working a case plan. And
who
so
has custody? Great grandmother?
the great grandmother does.
Usually it's just the grandmother, so we're going back, I guess, in the future, we'll go back, great grandmothers start getting this
My
responsibility.
daughter was her grandmother and she passed.
Your daughter's deceased, and that's the reason she's not involved with it. My
Yes.
condolences to you, you lost your daughter. Okay,
Judge.
now, so who's the father here? Is the father involved in this?
He's not here, but that's Zach Appleby. There's a lot going on in this case.
I can
regarding
tell.
Criminal allegations against a third party and petitioner's got some peripheral involvement in it, so.
Okay, what other relief do you want today?
Judge, I would just ask for a status quo order remain in place, that the visitation and everything that's been done in district court remain the same.
And I think that's all to be done.
Okay, we'll just submit an order to that effect.
All right, I will.
We need to get into it deeper. If there's not agreement, we'll be able to do that at a later date. Now, do you have the child? What kind of
Yes.
visitation is the mother getting right now?
The mother and my grandson are both getting every other week at social services office.
Okay, is that going pretty well, the visitation? Okay, well, thank y'all very much.
But I've seen on that.
Who's the badge?
Sheila Sells, Administratrix versus Jamie Lynch and Adam Watson.
Good afternoon, how are you? How you doing, madam?
Okay, what do we have here?
Good afternoon, Your Honor. This case was scheduled. I filed a motion to overrule the objections that Honorable
Okay,
Freeman.
here, let's do once upon a time here and speak up a little bit so I can hear you.
Okay. This case
Where's
involved
Sheila Sells at? You're Sheila Sells and you're an administratrix over whose estate?
Sammy Hensley.
Okay.
Property was sold through the master commissioner. After the sale, this attorney filed an objection. No answer was filed by the defendants. I filed a response to her motion to vacate sale.
Who do you represent? Miss Sheila Sells?
Yes, Your Honor.
And what was the objection predicated on?
Your Honor,
Would you identify yourself?
my name is Sydney Freeman, Your
You
Honor.
have to speak up and move behind the acoustics are bad in here.
My name is Sydney Freeman, Your Honor. I represent, Adam Watson and the,
Adam Watson, you
Yeah,
Adam
and-
Watson.
and the, daughter of the, decedent in the case. Our objection was that, my client had not been served. I think that, I was informed there were attempts at service. However, there were never, any parties that approached, the home, according to my client, to serve until
You're
after
gonna
the
have to
fact.
speak up. I'm sorry.
It's my understanding that Ms. Sells, is
Was he served?
Yes, Your Honor, I'll attach.
warning order attorney service.
Well, I mean, I don't, I hate that warning order attorney law.
Me too.
They go to the last address or they do this or that. but thousands of dollars worth of property are transferred all the time on warning order reports. And,
If I might answer that question.
if you move over just a little bit, and I'll let you come back and speak all the
Right.
time you want,
I
okay?
don't want to steal the podium, but we attached to our response a proof of personal service that Adam Watson was served by the Clinton County Sheriff's Office, Rick Markham Sheriff, January 18, 2024. The sale was not until March, so he was personally served. In addition to any warning
Show
order.
counsel that right there.
Yes, it's attached. Have you seen this? It was attached to our response. Did you get the response?
We may have, I've been out.
You've been ill, I understand. I'm sorry about that. That should also be in the file that I attached it.
Well, that kind of does away with my dislike for the warning order attorney law, you know, because he was personally served and he didn't file an answer. So the sale proceeded. Was he entitled to some proceeds from the sale?
Your Honor, he's not an heir, but he received a deed. I would consider that joint ownership, but it's subject to this Medicaid lien and all the other estate expenses. That's why this was filed, because Sammy Hensley is a nursing home resident for, I think, 3 years. And so Medicaid has filed a claim.
Who signed the deed to this gentleman?
His, I take it, girlfriend, the daughter of Sammy Hensley, who you also represent, am I correct?
Yes.
I speak, Your Honor.
Yeah, lady.
Your Honor, I wasn't served in a timely manner until they just sold it and brought me over the paperwork. And Sammy Hensley did not owe nothing on his estate. I have all the paperwork showing where he had type of Medicaid A and B. And his daughter has got the estate and his granddaughter. And I have fit and argued for their behalf on this.
Of course, I'm completely and totally lost right now about the thing. I read the motions didn't elucidate me very much. Illuminate.
I would have to say that its long-term health care coverage is not covered.
Well,
by
that's
the
Kentucky
insurance.
Medicaid who's
Exactly.
filed a claim here. Yeah. And
I have to claim for reimbursement.
There's no debts out on
there's been a Medicaid claim filed for the nursing home. Okay, that's what this is about primarily. What was the amount? Well, sure, everybody else has.
I think what he's saying is, at that time, there was nothing owed on Sammy's property until this all come in. I think that's what he's trying to say. It was cleared, it was paid for, but then he has these debts.
Sir, I'm saying he doesn't have these debts. Medicaid A and B has covered him. And these debts have been picked up along the way to try to make Sammy's look like he's deep in debt. And the man was a preacher at one time and he didn't owe no debts to the state. That's what I'm saying. And that his granddaughter and his daughter should get the estate.
Got 2 other granddaughters also that they don't acknowledge.
That's already been proved by the court that that wasn't true.
The reason the case was filed is because of Medicaid lien and
Did the Medicaid, how much was the Medicaid loan for?
170 something.
And that completely consumed the value of the property it was sold.
right, except for cost of administration of the estate, there'd be nothing left.
Do what?
Except for any cost of administration of the estate, there'd be nothing left because that would consume the entire, I think the sale was what, 33,000?
When did the deed to Mr. Watson take place?
March the 30th, 2023.
And the person was already in the nursing home. And so the lien already had statutorily attached.
Yes, I think he was dead at the time that, and the lien had already occurred.
And who signed the deed to Mr. Watson?
Jamie Lena.
Who
His
is that?
daughter.
His daughter.
Who? Yeah.
Which, they had been residing in the home.
Do what?
They had been residing in that home for some time with their daughter.
I don't see anything that can be done about this. He's properly before the court. It's a Medicaid lien. The judgment was issued, was Medicaid paid the money? Or we hadn't distributed money yet?
We have not filed a motion for distribution due to this objection.
Yeah.
Or objection.
Well, I'm gonna, rule against any objection that's not having been timely filed. Default them out. And, you can go ahead and file a motion. And when it gets final and appealable, you'll be able to appeal this action. This is not the end for you. I don't see that I have any other choice, seeing it's a Medicaid judgment that largely represents that it exceeds the value of the property, and he's in default also, so. Okay, thank y'all very much. Just go ahead. So take a look at it, okay?
Thank you.
And does it have final and appealable on it?
This is just confirming the report of sale.
Permanent report of sale, okay. Thank y'all very much.
There'll still be some more things.
Okay, Tony Bow versus Regina Bow.
Your Honor, Matthew Wells on behalf of Regina Ball.
Ball, excuse me.
Your Honor, this is a motion to hold Petitioner Tony Ball in contempt for violating this court's order back in January.
Where is the other side here?
The other side, Your Honor?
Yeah. This Regina is your client, right? Where is
Yes.
Tony?
I do not see Tony, Your Honor.
I don't see Tony either. So did you serve Tony?
Yes, Your Honor, Tony has been served via mail.
Flat Gap 612 Flat Gap Road.
Yes, Your Honor.
And how do you say he's violated the order?
Your Honor, Tony has failed to return the minor child to my client. There was a temporary custody order. Shortly thereafter, the contempt order was entered into in this court, granted by the Rockcastle Family Court. And that has now been dismissed, and it was brought back to here. And I'm filing this to have the custody, have the child.
Is Tony, Regina, you live here?
Yes, sir, I do. Yes,
Where
Your
does
Honor.
Tony live?
He lives at Flat Gap Road in Berea, Kentucky.
Where?
Berea,
Berea.
yes, sir.
And are you in contact with the child at all?
He comes to my home every other weekend.
And what's the temporary order say?
The temporary order has been dismissed in the J case.
So there's no order in place?
There is no order in place as of now.
But in the Rockcastle Circuit Court, she was awarded primary residential custody of the child.
That is correct,
Yes,
Your
Your
Honor.
And he was awarded first, second, and third weekend of every month.
Yes, Your Honor.
When school is in session, when school is out of session, he gets him majority of the summer. I see him every other weekend.
He refused to return the child.
Yes, Your Honor. Reason time shape. 2013, and he didn't. Statement. 12th day of January. Ordering him to return the child to.
And he didn't do it.
He did not, Your Honor.
Okay.
And then after this happened, Rockcastle, the record is to the back to 2013 order. Yes, ma'am.
Okay.
Yes, ma'am.
Okay, well, let's issue a contempt order.
And Your Honor, I have filed a proposed order. I don't.
Well, what I'm gonna do is I'm gonna do a contempt order
Okay.
and have him taken into custody and put into jail. And he can free himself from contempt by delivering the child to the mother here in Cumberland County and Clinton County. Otherwise, he will be held in contempt and be ordered to be here on January the 11th, July the 11th, excuse me.
Your Honor, may I speak?
If you like, if you don't like my order, you're not. for
I
my
don't
order.
want him put in jail. That is not my purpose.
Well,
My
let me
purpose
tell you
here
what,
is
let
to
me tell you what my
reinstate.
purpose is. My purpose is enforcing orders.
I understand, Your Honor.
And the only way that I can enforce orders, I had a previous order here and he went to Rockcastle County and tried to get around it by filing something up there. Now, if you don't want me to enforce the order, that's your prerogative.
I would just like to have the old order reinstated.
It is reinstated now, but what if he doesn't comply with it?
I understand, Your
It's
Honor.
in place and he's not complying with it. Now, if you want to write him a letter and tell him that you came to court here and were informed that the previous order is in place and that if he does not comply with it, the judge says that he's going to issue a contempt order and put him in jail. I don't want him in jail either. I don't want anybody in jail. I've sent people to jail today and there was only about one of them that I really felt like they really needed to be there. They were dangerous. The rest of them are drug addicts and a lot of problems. But you want me to enforce the order if I can't, if you want him to violate the order?
No, sir.
Okay, so y'all have to make that decision. So I won't issue a contempt order. Now, that's the only way I can enforce it. Just tell him if he doesn't comply with it,
I
I'll
would
put him in
advise you
jail.
go ahead because I would like to have my child back.
Okay, give him 10 days to produce the child to you and comply with this existing order. And if he doesn't do that, he shall report to the Clinton County Jail and be held in contempt for a period of 90 days. But he can purge himself of this contempt order. You want to draft it for yourself here? You draft it. Can you draft one like that and submit it?
Yes, Your Honor.
Okay, thank you very much.
Thank you, Your Honor.
Okay, good
May I
luck.
be
Thank you,
excused?
sir.
Absolutely. Cornett versus Deborah Lee, Don Franklin, Monticello Inc. and West Bend Insurance Company.
Afternoon, Judge.
How you doing?
I'm doing well, sir.
Yeah. What we got here?
I'm John McCracken for Kentucky Associated General Contractors.
Yeah.
It's just a motion to intervene. We paid work comp benefits, my client did. And so we're operating under 342-700 just to ask so we can participate.
Okay, you have any objection to that?
No, sir.
Well, that's an easy trip.
It's an easy one, that's right.
Okay.
Easy for the court as well.
Well, yeah, well, that's better than some, as you can see. We'll electronically file if you submitted an order.
I tendered just a generic order, yes.
Okay, we'll go ahead and electronically file it. Y'all be on your way rejoicing.
Thank you, Judge. That's all I
Have
have.
a
now.
safe trip.
Thank you, sir.
Yeah. Cornett, that was it there. It's a double file. There any complaint? So. With the double file there.
Separated by the other tabs.
Okay, this is a motion to approve application for transfer of structured settlement. Yeah.
Good afternoon, Your Honor. Chris Cathy for Asset Security Consulting, the transferee. Can you hear me okay?
Kinda can hear you. It's a little.
All right, let me see if I can.
Wait just a second. Let me put these things on. I might be able to hear you better.
All right.
Okay, go ahead and try it again.
Okay. Chris Cathy.
I can hear you well.
Okay, perfect. All right. And then the in-rate WW, the gentleman's name is Wade Weston, the annuitant payee. He's supposed to be on this Zoom call.
Yeah, Mr. Weston, Wade Weston's there. You need to turn your camera and your mic on. Mr. Weston, I see you there. There you go. Now turn your camera on now. Are you Wade Weston?
Yes, I am correct. Wade Weston.
Where are you located today, Mr. Weston?
4844 Wisdom Dock Road, Albany, Kentucky, 42602.
Yeah, is there any reason you aren't personally here in court today?
Yes, I am trying to get some money for a home and to pay off some loans and some debts that I accumulated in my previous marriage.
Okay.
Your Honor, I think to answer your prior question directly, it was our understanding that we could attend by Zoom. I apologize to the court if I had misinformed Mr. Weston about his ability to attend by Zoom.
I just wondered why he wasn't here.
Yeah, it's my fault, Your Honor, and I apologize.
I like to see people if they don't have to see. Does he have some kind of disability or what kind of shape he's in, that sort of thing when I make these judgments, but that's okay, we'll go on to the next thing.
Sure.
Now, notice of a hearing to, what kind of, he has a structured settlement, is that correct?
He does, Your Honor. Let me, if I may, I'll just roll through the background here on this matter. Mr. Weston is the recipient of a structured settlement that arose from the wrongful death of his father some time ago. He's currently getting a stream of monthly payments. He is proposing to transfer 276 of those monthly payments to my client. The aggregate,
how much are the monthly payments?
They're $2,519.53, and there's the final payments $4,827.74. When you add all those,
that's yeah. Go ahead. That's the totality of the payments that are.
No. I'm giving you the monthlies. There's 276 of those payments. When you total them all up in the aggregate, they're $981,192.48. If you apply the federal discount rate to arrive at the present value, those payments are $503,959.79. The proposed transfer price to Mr. Weston from my client originally started at $231,368.47. My client has agreed to increase that price to $235,619.76. So they're up in it nearly $4,000. By way, Mr. Weston alluded to or started telling you the reasons why he needs the money and wants to do this transfer. He's got some debt from his prior marriage. He's got some legal expenses as I understand it. He's recently remarried, has some debt as a result of that. He and his wife, his new wife, are looking to buy a permanent home. And this money will enable him to take care of that debt, avoid imminent financial hardship.
Let me ask you, he's got 276 payments left. Is that the totality?
No. He's got, let me tell you what he's got left. I was giving you the payments that he proposes to sell.
I'm asking what total payments that he's getting.
Oh, he's getting 200. Yeah, I'm sorry. He's getting $231,368.47.
I'm not communicating well with you.
It's okay.
What is the total amount of the structured settlement he has? You said he was going to get, he's selling you monthly payments.
Yeah.
Of 200 and of how much a month? $2,500 a month. 276 payments for 276 months. Does that completely consume his structure?
It does not. It does not.
Well, tell me how much he's got left per month.
Okay,
after the 2,500. What's he getting per month?
Right. He's going to get, or he's going to still have $4,731 per month until September 2025. those payments they'll increase next year. There's a 3% adjustment annually on these payments. Then he's going to have left also $2,500 per month with that 3% increase from October 2025 until September 2048. And then he's going to have another $9,900 a month from October 2048 until his death, or for as long as he lives, to maybe put it in a little bit more positive.
Have you been here before with this settlement, trying to sell this judgment that you have?
Are you asking Mr. Weston?
No, yes, I'm asking Mr. Weston, yeah. Have you been in this court before? Yeah, and I turned you down previously, didn't I?
Yes, I have, Honor.
Yeah, and I asked you to get an attorney.
Yes, and I did get an attorney.
Yeah, who was your attorney?
My attorney's name is Kevin Hoskins.
Where is he located?
I'm not sure where he's located at. But I just found him online. So,
Your Honor, Mr. Weston had a prior deal that he had pending with a different factoring company, and he decided he wanted to back out of that deal. Mr. Hoskins' firm, the Dressman Benzinger firm, they've got offices up in Northern Kentucky, Louisville, and Cincinnati. Mr. Hoskins runs the Cincinnati office, but one of his colleagues, as I understand it, represented Mr. Weston in getting that prior case dismissed. So he did have counsel for that proceeding. I have not communicated with the DBL firm related to this particular hearing. But if we needed.
Okay, before the assignment of the $2,500 a month to you, what's his total payment he's getting a month now?
Mr. Weston, how much are you getting a month out of this annuity?
A little bit over $4,700 a month.
So he's gonna have less than $2,500 a month coming now, once he makes this assignment to you, correct?
Well, no, what he'll get, Your Honor, is he'll get until for another year, he'll get $4,731 a month. And then thereafter, he's going to get $2,500 a month. And that goes through September of 2048. And then 2048 is going to get $9,900 a month.
But 2048 is about 24 years from now, correct?
Right.
So between now and then, he's gonna be down to less than $2,500 a month.
Well, I mean, where he's getting that, it'll be actually $2,500 a month. Starting in October of 2025. Up until then, it'll be $4,731.
Well, I mean, your money comes out starting in October.
No. Our money does start coming out in October of 2025. So yes, those payments.
Okay, after October 2025.
Yeah, I understand what you're saying. Yeah.
So he's gonna be getting a little over $2,000 a month. Yeah. He's getting $5,000 a month now, right? And he's gonna be getting 2,000 something a month. You understand that, sir, that you're just gonna be, starting in October, you're just gonna be getting a little over $2,500 a month?
Yes, I understand that, Your Honor.
Have you gone to any local banks or anything to try to get financing for your financial problems here? Have you gone to any local banks or anything?
I currently bank with People's Bank and Trust, but I'm I didn't like their interest rates, so I chose to go this way.
Well, if you don't like their interest rates there, you sure the heck aren't gonna like the interest rates that you're getting or the amount of money that you're paying this company that's gonna buy your annuity. So I'm still convinced from your answers and things that I doubt the financial sophistication that you have as I did before. So I'm gonna put this off for a month and request that you get local counsel here, someone that you can come and sit down with and look at this situation. And if you come back with advice of local counsel, I will consider this again. But until then, I'm not gonna approve it. Okay?
All right, thank you.
Your Honor, can we continue the hearing out to the next motion hour? And
That's what I was gonna do, like on July the 11th.
Okay.
July the 11th, and I want, there are several competent attorneys here in Albany, Kentucky that you can meet with personally and go to their office and let them take these documents with you and let them explain these documents of what you're getting paid, what the what the discount rate is, what kind of return you're getting. And if you come with local counsel that can convince me that you understand the implications of this, then we'll take another look at it on July the 11th, okay?
All right, thank you.
Thank you, Your Honor.
Thank you all very much.
Have a good day.
Greg Sandel versus. That's a different order. Are we finished?
Yes.
What do you have, Ms. Capps?
Judge, I've got a Cumberland County case that we asked to be heard today to get it before the court fairly quickly. It's Eric and Leslie Connor versus Honeycutt et al. 24 CI 36.
Do we have any documents on it?
Yes, I sent those and talked with Jessica at the clerk's office, and they were supposed to send them here.
See.
Which is the fact that the court.
See, the clerks,
I had no notice.
what is it here? I mean, you didn't call our office, you didn't call Megan or anything. So you tried to schedule this with the clerk's office
Yes,
in Cumberland County.
yes.
Well, see, you just can't do that. I mean, you can't, the clerk's office does not do our scheduling. So what kind of motion is this?
Well, it was just a motion for status quo temporary custody order while this case is pending until we can get the father.
Do I have the case in front of me? Have I thought this was a Pulaski County case or something?
No, they had, previously, there was a Pulaski County case filed, Judge.
Yeah. I'm confused.
All right. I can just give you my file that's got all the stuff that's filed, and I asked when I called the clerk's office if this was what I needed to do, so I apologize, Judge.
Who is the other party?
One of the other parties is Brittany Jo Vaught, was the mother. We filed an entry of appearance on her behalf and an affidavit. And then the father is Douglas Richard Honeycutt. And essentially, he fell off the face of the earth, my clients, as of June last year. He wound up going to jail, getting in trouble in September. He just recently entered a plea in Adair County.
Get back there so they can see. Yeah.
I was just gonna let you see the file for
I'm not gonna look at the file. You know,
He
I'll be
recent,
glad to take a look at the file later, but I'm not gonna be signing anything. So who's interfering with any kind of custody orders? Why do you need a status quo?
well, at this time, because my clients have been letting the child go back and forth with the grandparents, and they're just concerned about the
Who
father.
are the grandparents or the parents of the mother?
They're the parents of the father.
Father.
And they just want to get something in place to make sure that when this child goes, that the father can't withhold the child with everything that's going on. He actually signed a power of attorney to them for the child and has abandoned, they had the child in Cumberland County School all last year. He's been in their home. They just want to make sure that until we can get into court and address this, that we get a temporary status quo.
Well, they don't have an order.
No.
And appointing somebody as attorney in fact is revocable. So he could revoke that, couldn't he?
Yes, he could. But at the same time, statutorily, they meet the definition of de facto custody. I know we've got to present that to the court.
That's what we've got to get done.
Yes,
So I would suggest, when's our little lady person?
the 27th.
So you still have time. File a motion to be heard on the 27th to serve the parties. To amend, I guess, what kind of proceeding is in Cumberland County?
I filed a de facto custody petition in Cumberland County.
Have they all been served?
We have not been able to get service on the father, and he's on monitor probation. I've contacted the probation office, and that's a concern that my clients have, that I mean, everybody knows where he's supposed to be, except somehow in Pulaski County, he's not being served.
Well, I would, you can always hire a special bailiff. What I do is hire a special bailiff and make sure you get served and you come down and they think he's gonna file, he's gonna fight the status that they have.
They've reached out to him and tried to communicate with him to see if he would just agree, and he won't respond.
How do they statutorily qualify as,
Because the child has been living in their home.
has it ever been under a court order that the child lived there? See, I've bumped into that thing in the past where the time doesn't start running if somebody's living there under a court order.
He was not living with, he's been living with them continuously since May the 11th of last year with no court order in place that they have custody.
Yeah.
So he meets the standard. There's no existing court order that addresses any of their involvement.
Well, and you served him today. You can't, sir, you hadn't been served because you.
But we've tried to get his
I
paperwork
know,
served.
but, so he's probably tipped off that they're probably trying to interfere with, or that he can get the child back. So that's tactically or strategically, that's a problem. I would just go ahead and have him served and have him be there in Cumberland County Court day with this motion as far as establishing them, and then you can file a temporary custody motion at the same time if they're
Which is
recognized.
what we had done to have it heard over here for this motion day, but I will refile it to be heard for Cumberland County.
We just didn't get it, and it's, and you had, on these things, I'm a stickler to make sure that there's service on the other problem before we start signing these things, because they're these,
Of course, the order I proposed, Judge, was just until we could get back into court for the next motion day.
I know, but you don't have it here. You know what I mean?
Yes.
He's not here. And he's not here. These are, I mean, we've been burned on several of these things where we had these, facto custodial situations that we thought, and then ended up in the court ruled that they weren't de facto. And I'm not gonna go down that road, so. Yeah, and what's the next date? 27. Well, it's just a few days. Surely you can get him served and get it over there. And then we'll make sure that all the T's are crossed and I's are dotted and get served. And we'll do what we need to do. Now, they still have the power of attorney, is it?
They still have the power of attorney, yes, Judge. I mean, essentially, he's abandoned this child with him.
Well, now, what about the grandparents?
Well, the grandparents don't have any custody or
Well,
anything.
is that his parents?
Those are his parents, yes.
And how do they feel about this?
I'm not aware, Judge. I mean, they have allowed this child, they've not tried to take the child from the Connors
Well,
home.
I'll see you over there on the 27th. We'll
Okay.
make sure you have it served by then, okay? And then we'll have the de facto custodial thing and then temporary hearing that day. Okay?
All right.
Okay, thank y'all very much. So that conclude the Clinton Circuit Court. Okay, thank you very much. I got orders to sign. This is one we heard today.
Yes.